colors light up the air, faces tense as stories tear, truth and lies like a tangled dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes stand, shadows cast. Whispers loud like wildfire spread. In this game, none's ahead. International eyes on the scene. Lines of right, blurred and lean. Arrested dreams, shattered glass. In this court, who holds the past?
Hello, good morning. Good morning, everyone. Need to do a bit of a test because I have got a new mic and I need to make sure that it's all working and yeah, make sure that it's working and you guys can hear me. If you can, just let me know in chat, and we'll be starting soon. Anyway, starting doing the case of a view and everything, and talk about this case. So we've been doing this type of thing of kind of overview some cases that were not like live stream 100% over in the true crime world, and they like they're not really talked about. This is like small cases that people, it was not really like televised, and that's great. Thank you, Nightbot. Hello, welcome in. um so yeah, so it's cases that wasn't really out there, or not by the usual suspects like law and crime. Well, the Court TV does have them, but it wasn't transmitted live. It was, the way that they talk in the middle and everything. So we've been doing those kinds of types of cases lately, and talk about, we've done the first one a couple of weeks back. Last week we did another one, and then today we're going to do our third, and then we're probably going to carry on doing this type of cases when even the big ones are starting, when the courts start back up again next week. Because I really have been enjoying doing this, because it lets me do my research, finding the videos. We can talk about them, give our opinions about, and then just talk about it. And it's not like a long day that we have to sit through a lot of testimony and everything. It's short and sweet and direct to the point, and then we can have already the verdicts, and sometimes we already even have sentences, and it's puts the knowledge of that case and shines the case out there, to give a bit more of justice for the victims and for the families. And yeah, so today we're going to be talking about this case out of North Carolina. North Carolina. So it's about this. What you're seeing on the screen is actually the one of the lawyers of the case. So we're going to talk about Taiseer Taz Zarka. Is the owner of a convenience store in Raleigh, North Carolina, or was. I don't know if he still has the shop or not. And he unalived a shoplifter, or a suspect of a shoplifter, in his store. So he suspected that someone was stealing from his store, and he confronted the gentleman that was suspecting of shoplifting. And the victim is called Mark. And then he stabbed the suspect, and then he end up passing away in the store. There is a lot of there is videos that customers reported, that there's a lot of customers that there are of former customers and employees that testimony throughout the trial, that happened over a period of 6 days. This was about, I think it was before Christmas, I believe, this case, just before when court stopped. So yeah, December 10, so that's kind of started, was about 6 days. And then the jury heard a lot of testimony, a lot of information about the case, and then there was the whole case. Then a story that we're gonna hear from a store employee that testified, that Zarka, our defendant, suspected that Mark Garrity, was stealing a Gatorade. So all of this was about a drink, Gatorade, and then tried to search the bag of Mark, but Mark didn't want to, so he was it's just a whole situation. So I was able to find actually quite a couple things about this case in terms of videos, and then there's a lot of information like we did in the last trial, day by day, that talk about a little bit about and see what it's out there on this case. So starting on day one we had the normal, the prosecution and the defense openings, that we do have the video. There is the video that is actually on screen right now, and then we can carry on, starting with some testimony that was on day one, and then come from there. I mean, just make sure that you like the stream. It does really help. Share the stream if you want to. I just need to do, while we're listening to the openings of for this case, I need to send out a tweet. Oh, and do you still say tweet? I think you still say tweet. I don't know. But anyway, I need to tweet it out to make sure, like, people know that we're alive, that we're here. It is very cold in the UK today. I am very cold. I actually have a heater right next to me. I hope you guys can't hear it. And I hope this mic it's good, because it was an investment for the channel, for the quality, and hopefully it's all right. So without further ado, let's start hearing the openings of the case of this trial out of in Raleigh, North Carolina.
I think the evidence may show you that. He certainly did have a Gatorade in his bag. That Gatorade, though, leads the defendant to pull a knife, to approach this young man with a knife in his hand, while Mark Garrity has a bag in one hand and some ice cream in the other. He approaches him with a knife at his side, grabs the bag. Mr. Garrity is pushed back onto the cooler, where the defendant stands over him with a knife and threatens him. That movement then leads back to the corner of the store, where it continues. There are other people in the store. There's a toddler in the store, walking around, while his dad's in the store, or someone's in the store with the child looking for a cell phone. They're trying to buy things. There's a group of young ladies that the defendant walks straight through, get out of the way, knife by his side to go straight to Mark Garrity. Before Mark Garrity's even made it to the register, made it to the door, he's approached with a knife. While there's a surveillance video in the store that captures most of what happens in the store, that surveillance video, you're going to find out, doesn't have any sound. There's a third person who's kind of involved in this altercation to a little bit, and that's one of the defendant's employees, Nathan. Nathan goes over, I believe you'll find, to kind of, hey guys, let's separate what's going on here. Just, if you took something, give it back. It's not that, let's sort it out. At this time, there's this struggle going on between the defendant and Mr. Garrity over this bag. All the while, the defendant has the knife in his hand. And I believe when you watch this video, you'll see the defendant's not just holding the knife by his side the whole time. He's directing at certain points where to go at knife point. Gets him in the back corner of the store. And while I said that surveillance video doesn't have any sound, well, it's 2024, so we kind of know what does happen, right? If there's something exciting going on, somebody, and we just spent about 5-10 minutes talking about these things, is going to be standing there with a cell phone. And what is happening is there's a young lady in that store, and she's filming the whole thing once it goes on. She's one of those young ladies that was standing right at the register that the defendant walks by when he has that knife out. And she'll narrate the event to you on the video, and you'll hear it. It's not always the nicest things that she's saying. There may be some colorful language in it, but remember what's going on in front of her at this point in time. And, you know, had she been perfectly quiet, you might be able to hear a little bit more, but luckily you are able to hear some of what is being said between the defendant and the victim in this case. And what you'll hear is the defendant saying, I didn't steal anything, man. I didn't take it. You gotta let go of the bag. You gotta let go of the bag. I don't have to do shit. That's what the defendant says. At knife point. After a couple of minutes of being detained in this store at knife point, and mind you, all the while, nobody on the defendant's behalf has called 911 yet. Nobody has contacted the police about this potential larceny. And remember what it's a larceny of. Like a 20-ounce blue Gatorade. And I say larceny, but it's not even really a larceny yet. It's a concealment. It's a shoplifting. And the only real evidence that we have that it was a larceny or shoplifting is that, you know, they see him on video in the back buy the Gatorades, and there's a blue Gatorade in the bag. So I'm not going to deny, and I'm not going to stand here and insult your intelligence and say, we don't believe that he was stealing, trying to take something that didn't belong to him. Okay? I think the evidence is going to show that. But the evidence is also going to show that while he's been detained there for several minutes, at knife point, in a corner with two men surrounding him, one of which arguably trying to calm everything down, he says, essentially, I've had enough. I'm getting out of here. You're not going to hold me here at knife point anymore and not call the police and have everybody handle this in an appropriate and reasonable way. I'm leaving. And at that point, at knife point and with racks beside him, he attempts to get free, to get away from this location. The defendant does not let him go. Again at knife point, threatening him with a knife. The victim, you can be heard at one point on that cell phone video going, stab me then, stab me, stab me. You're going to go to jail if you stab me. He fights his way, tries to fight his way out, and I'm not going to sugarcoat it. He tries to get out of there, and it gets physical. And at that point, the defendant takes that knife, and it's clear at this point that he stabs him several times. He stabbed, the doctors are going to tell you, 3 times at multiple depths inside of this person. 2.5 inches, 3.5 inches, 4.5 inches. One of those straight to the heart, through the cavity into his heart, puncturing his heart. The victim falls down. You'll see he gets up, makes his way out the front door. All the while, that cell phone camera is in tow. They're watching it, narrating. There are other people around, and you'll see it. And this is the video that we've been telling you about, right? He goes out into the street alone without that bag, collapses in the street of downtown Raleigh in broad daylight, and bleeds out right there. Now, the defendant never goes outside, never walks out there to check on him as he's dying in the street and say, man, is he okay? Everybody, let's get some pressure on that wound. Everybody take care of him. No. While Mark dies, what does the defendant do? You'll see that the defendant mops. While Mark dies, the defendant mops. He goes straight back into the back and wheels out that little yellow bucket of water, starts mopping the floor. Get back to business as usual. Okay? Business as usual. Gotta get back to selling things. Clean it up. So you're going to hear that this happens. You're going to hear the video. You're going to hear the people in that video and what they are seeing, their present sense impression, the things that they are observing at that scene, their emotions, what they saw happen, what their reaction to what they're seeing happening is. And at some point, yes, you will hear what the defendant has to say about this. And as we told you, he tells the police that he thinks it was self-defense, and he gives an interview to the police. Okay? And I'm not going to recount every fact of what the defendant is going to relay to you in that statement, but I will ask that you listen very closely, okay? Listen to the details that matter in that story that he gives you. And what I want you to do, as we talked about in jury selection, is to receive that evidence and apply it to the law, right? Well, I want you to receive that information that he gives you in his statement and apply that to the undeniable things that are on that video. See if they add up. That's what the evidence is going to be in this case. Now, 99% of the evidence that you're going to hear about in this case, I'll be honest with you, and I think that Mr. Newton's going to stand up here and tell you, we agree on, okay? What it's going to boil down to are those two issues, really, right? It's kind of, is there malice here, and is this self-defense? And so the judge is going to give you the law about that, but the fact that the defendant is the one that took a knife and stabbed the victim, Mr. Garrity, and that stab wound is what killed him, not in dispute for you. This isn't a whodunit. This isn't that type of case. What this is it's what is it? And so if you keep an open mind, as you've all sworn to do, and listen to the evidence here, at the end of it, I'm going to stand up here, Mr. Newton's going to stand here, and we're going to talk to you about what we think it all means. Okay, we're going to try and explain why our position is the position that you should believe in, and that it beyond a reasonable doubt that I've carried my burden to you. And when we get to that point, what I'm going to stand here and tell you is that this was not self-defense, and that the defendant is guilty of second-degree murder. So I want you to listen closely to what he says, pay close attention to the video, and I would also ask you to pay close attention to what the other witnesses who are present don't say they heard, and the things that are not found at that scene. Because one thing that the evidence is going to show you is that Mark Garrity never had a weapon. Mark Garrity had ice cream, and Mark Garrity had a Gatorade. But he never had a gun. He never had a knife. The only person who instigated this event, you'll see through the evidence, is the defendant with a knife. And so, again, thank you. I know it's been a long time getting to this point, but now that we're here, you actually get to do the work, and we appreciate it. And again, at the end of this, I'm going to stand here, and I will ask you to find the defendant guilty of second-degree murder. Thank you.
All right, thank you, Mr. DA. Will there be an opening statement?
There will be, Your Honor. Can I have the electron, please?
All right. This jury is Mr. Newton.
Thank you.
Thank you, Sheriff.
Good morning, ladies and gentlemen. There are 34, on or about April the 6th of last year, there were 334,503,708 people in the U.S. And 482,295 of them in Rockland. And all those people were going around and living their lives and doing things. And you're here today because by whatever chance, two of those people ended up having their lives intersect. And as a result of that intersection, their lives were changed forever. And one was lost. And there's not one thing that either you or me or anybody else can do about that. So your job is going to be to come in and figure out, under the law, what happened and what ought to be done about it. You're all good citizens, randomly brought in here. You don't know anything about the case, don't know anything about the people, but now you're about to learn. You're going to learn basically 3 segments. You're going to learn about before, you're going to learn about during, and you're going to learn about after the event. One of the things that you're going to learn about this man is something about his background, his history, and what he does. And you will hear from him that he was born in Gaza, in Palestine, to the extent that that country actually exists. He was born in 1963 and lived there until he was about 3 years old. And his parents took him to Kuwait, where there was more opportunity to do that. He lived in Kuwait until 1980, and then he moved to the United States of America. Pursue that dream that so many people around the world want. To come to this country where there's freedom, where there's opportunity, and where those people who are willing to work hard and do right can succeed and thrive and prosper. When he moved to the U.S., he started college at Shaw University. He attended school there until about 1982. And between 82 and 83, he was at East Carolina University studying electronics technology. In 1984-85, he obtained an associate's degree in electronics from West Tech. And finally, in the school year of 86-87, he was given a BS in business management and accounting from Shaw University. When he got that degree, he was attracted to go back to the Middle East to work. He moved back to Kuwait. He worked in the shipping and trading industry and was doing well. But his time in the United States of America was a strong draw. He was in Kuwait in 1990 when the Iraqis invaded Kuwait and lived through that. And while he was there doing that, he actually took it upon himself to help smuggle numerous American families and people out of the country. In 1988, he moved, in 2000, he moved back to the United States of America, where he opened up some businesses. His businesses were selling things to people, operating at stores. He has been in that business ever since. From 2005 until today, he focused his attention on operating stores in downtown Raleigh. The store that he's operated is the subject of this event, or the location where it happened, is Taz Store. It's at 207 South Bloomington Street. And he's been there for 17 years. In 17 years, he's seen businesses come and go, and more go than come. His store serves a function to the people of that area. It would otherwise be a food desert. In fact, if you're down here, I know you can't go there, but if you could, there's very few places in downtown that you can buy anything. Buy soda, buy bread, buy whatever it is. He's operated that store for 17 years, and in 17 years, you will hear that this incident of shoplifting or attempted larceny or more is just one of hundreds of times that he's had to interact with people. And he will tell you that in those normal interactions with people, it usually goes down like this. The law allows the merchant to confront and detain an individual to determine whether, if the owner, the merchant, or a clerk, or whatever, has probable cause to believe that they're shoplifting. Shoplifting is unlawful concealment of goods while you're on the property of the merchant. In this particular case, it's Gatorade. And the way that most of those interactions go on, with Taz, and in fact, probably most merchants, is that when somebody is suspected of doing that, they are interdicted either by the clerk, the store owner, store security, whatever you want to call it, loss management, whatever, and it usually goes down like, I need to stop you right there, I need to look in your bag. If you got property, I need to look in your bag. You will find from the way Taz will tell you that for years and years and years, and doing that hundreds of times, the vast majority of the people are cooperative. They'll just give it up. And if it's a case where they just simply didn't have the money, Taz will tell you that a lot of times he just lets them have it and maybe tell them, don't ever steal from me again, get out of my store. If they've got the money to pay for it, a lot of times it goes down to pay for it. Don't ever steal from me again, get out of the store. Most of the situations where he has to interact with people, he will tell you the cops never get involved in it at all. Because if the cops come, the cops will write somebody up, and maybe they deserve it, and maybe they don't. Maybe they'll come down to court, and maybe something will happen with it, or maybe something won't. And if he gets into the court system, then he's got to, they come down to court, testify, take time out of business, and all the rest of that. And like I said, a lot of times nothing happens. You will hear and see from the evidence that the place where this store is not like where most of you guys live. It's different. It's right adjacent to the bus station. They're transient people. They're homeless people that are there. They're people who use drugs and drink and they'll fight. And there's all kinds of stuff that happens there. It's a little bit like the Wild West. The Taz does it, and he does it and provides a service to people who otherwise wouldn't have anybody to provide that service. In the store, there are a number of security cameras that are in there. They're there for the purpose of documenting what goes on and to help him deal with people who would steal from him. What they call shrinkage or inventory control. For him, it's like trying to keep somebody from stealing and blind. You're going to see the videos. There are 5 of them in the store in different areas, and a lot of that goes on is important because there is pretty good video from different directions as to this actual event, the struggle, fight, call it what you want, that resulted in the injury to Mark Garrity and caused his death. And to make it easier for you to really see that and understand it, those videos have also been cropped to cut out things that are extraneous. They've been slowed down, some of them to quarter speed, and on some of them it can be shown to you and will be shown to you frame by frame, pieces of second at a time. In terms of things that happened before that, you will also find out that Taz has a fair amount of interaction with law enforcement. They're coming in his store all the time because there's a pretty good police presence down in that area. In this particular case, even though there were efforts to call, and the woman who was doing the cell phone video, when Taz yelled out, call the police, yelled back, they've already been called. In fact, some people are going to come in and testify about what kind of a man he is and how he conducts his life and how he does his business. And at least a couple of those are going to be police officers. You know them well. Been in and out of the store and dealt with them for years. Because Taz has a history of cooperating with law enforcement. Has many times given them access to the security camera footage when they're looking for suspects or individuals. I don't know a lot about Mark Garrity other than the fact that he's a young man and he died in a bad way, and it didn't have to happen. We do know, and I believe the evidence is going to show that he did have an addiction to various controlled substances as well. Some of his medical records are available, and they will show that. The records will also show one of the things that is going to be an issue that you're going to have to sort out is, well, why did this go down the way it went down? Okay. Because in essence, what happened was, on the store video that was available to Taz, he saw Mark Garrity take some of his product. It was a drink. The first one that's clearly on video is a Powerade. And he takes it and he looks at it. He has it in his hand. He has the bag in his hand. He unzips the top of his bag. And just before he's about to put it in the bag, looks up and notices that there's a can. He puts it down, goes back around behind where there is shelf with merchandise. He's then opening up and closing various doors where the sports drinks, including Gatorade, is found. He messes around there where you can't see him, and then when he comes out of that room and comes back into the other room, on video that's available to Taz, he doesn't have any drink in his hand. Where's the drink at? Taz, at that point, being a merchant, is authorized by the law to detain him, to stop him, to ascertain whether or not he is in fact stealing. Because his detention cannot last longer than the time that it takes either for the police to get there or to ascertain that the person is not stealing. In this particular case, the only way to ascertain whether or not Mark Garrity was stealing from him was to access the bag and see what was in it. You're going to find out from the police, and in fact, Mr. Latour acknowledged that what they found in there was some blue Gatorade. Importantly, that blue Gatorade was cold. It didn't come in from someplace else. It came out of the cooler and it went into Mark Garrity's bag. And he had zero intention of paying for it. And Taz was authorized under the law to seek to find out if that was true. And he went up to Mark Garrity, and you'll see this on the video, and grabbed the bag and said, I need to look in your bag. What's in your bag? Most of the people that Taz has dealt with in those similar circumstances comply. They say, I'm sorry, man, or yeah, go ahead and look. Maybe you're wrong about it. I got no problem looking at it. But Mark Garrity absolutely and positively refuses to allow Taz to do that. You're also going to hear from Taz about the fact that he had a knife with him and that he actually had it out. While the testimony is going to be while at the counter watching the store video and seeing the things that gave him good reason to believe that Mr. Garrity was stealing stuff from him. There were 4 women that were in front of the counter, and they were aware of what was going on because Taz was also brought Mr. Nathan Cowles, I guess, or Cole, we'll find out when he comes in, who was the store clerk who was doing something else, and brought him up so that he could take over the register. While he's ringing up stuff, he points to the monitor so that Mr. Cowles can look and see what the person is doing. While they were discussing this, there were, again, 4 women that are there. And when Taz says, Mr. Garrity starts coming and Taz goes around, one of the women says to him, "Be careful, Taz, he may be carried." Which Taz understood to be that he might have a weapon. So when Taz went up and grabbed the bag to try to determine whether he was stealing them from him or not, he asked Mark Garrity if he was carrying it, if he had a gun or a pistol in the bag. And Mark Garrity replied to him, "I got a pistol in there, I'll open my bag and shove it up your ass." Which caused 2 things to happen. Taz will tell you that he immediately got even more concerned than he was, and he knew from that moment the one thing that he absolutely positively had to do was not let go of the bag. And they fought over that bag. They fought over that bag, they came together. And for about a minute and a half, they were struggling over that bag. And then, as Mr. Latour told you, Mark Garrity had had enough. He was going to break out, he was going to go. And he forcefully pushed Taz, had him turned around backwards, pushing on the back of his shirt and his neck. Taz turned around, and as that happened, they came together up against part of the counter. And the video, we would say, depicts where he got injured the first time as a result of them coming together. Taz was at that time, and earlier, you will see that he had his knife, and he was not attempting to harm Mark Garrity with it. The only thing that he was doing was trying to cut the straps of the bag so that he could literally cut the bag away from him. As a matter of fact, in the course of it, there's evidence that shows that Taz got cuts on his hands because of what he was doing. But when Taz finally was able to cut that bag away and pull it loose, instead of just running out the store, Mark Garrity came, charged him as Taz was bending over and hit him forcefully in the head. And at that time, Taz, you'll see, just tried to get him off. And in the course of that, there's like 3 seconds. This entire thing happened between 3:40:03 in the afternoon and 3:40:06. You will see really the moment where Mark Garrity, the knife struck him in the chest, and it tragically went between 2 ribs and hit him in the heart. At that point, he does back up, holds his chest, and turns to go. And Taz just comes and looks at him to make sure of what he's doing. And then at that point, instead of running out the store, Mark stops and comes running up and does a karate kick and tries to kick Taz in the face. Falls flat on his back. Then realizes, I guess, that it's over and he needs to go, and he runs out to the street and collapses. Now, the big question is going to be, why did this go down so different from all the other regular piddly shoplifting cases where somebody may just get a slap on the wrist with it? What was going on in Mark Garrity's head at that time that caused him to fight so hard for so long? The 2 things you're going to find out, and this is kind of before, one of them is before and after, and the other is after. You're going to receive evidence that 1 week to the day before this happened, Mark Garrity was in this very courthouse, and he pled guilty to felony breaking and entering and larceny, and was given a suspended sentence, and he had a sentence of 5 to 15 months hanging over his head. He was put on probation, and probation has terms. And among those terms, and the most important of those terms is, do not commit any other criminal offense in this or any other jurisdiction. shoplifting is a crime, stealing is a crime. So for Mark Garrity, it was not going to be a slap on the wrist. It was not going to be something that would come down to this courthouse and then just get overlooked. For him, it meant prison, because it was a clear violation of his probation. You will also hear from the testimony of the pathologist that at the time that he died, they routinely, in the medical examiner's office, they draw blood and they check for alcohol and drugs. And in this particular situation, when they did that checking, they found he had cocaine and fentanyl in his system. So when you're trying to figure out why this thing went down, you will have evidence that this was going to be of major effect to him, and he also had the mental effects, whatever you determine them to be, of having cocaine and fentanyl in his system. The store videos will begin, and there is a total of about let's see, 15:35, and out the door at, there's basically a minute and a half, this whole thing happened. We do know, and you will find out, that the cops were called, but unfortunately, sometimes when seconds count, cops can't get there for a few minutes. In the after, you will see, tragically, Mark Garrity lying in the street, and for practical purposes, dying. He received heroic treatment at Wake Med. The EMS people were able to get some calls. He was delivered there. They opened up his chest. They did manual cardiac massage. They did everything that modern medicine will allow them to do, but it was not. By virtue of exactly where that injury was, it was not possible to save. Mr. Latour indicates that Taz stayed in the store, and he did. There were still customers in the store. There were still people coming in and out, and there was blood on the floor. And he didn't want people stepping in blood. I mean, people were really concerned about that kind of thing. He cleaned up and tried to make it more safe for people. When the officers came in, he was very forthcoming to them. He said, "Listen, man, it's on video. You can go up." He had no problem. Gave them the video. Gave them his knife. Showed them where he had apparently injured himself. He talked to several police officers there, told them what happened, did everything that he could do to be cooperative. One of the officers was there, had the opportunity to pick the bag up that Mark had, open it up, and yes, indeed, there was a bottle of Gatorade, and yes, indeed, it was cold. Taz is asked to go downtown and give a statement. Told he's not charged with anything. He goes down and voluntarily does, and sits and gives him a statement, waives his rights to remain silent. And Detective Heflin had him down there for, I guess, from that after, shortly after this happened until late in the evening. They took his clothes, or at least his shirt, and took photographs of him. And at the end of that interview, Detective Heflin said, "You're free." And Taz was free, didn't go anywhere, didn't run away, didn't try to hide. No charges were filed against Taz until April the 19th, almost 2 weeks later. Now, he is charged with second-degree murder. And again, I mentioned to you that by virtue of his being a merchant, he is authorized under the law. It's not just like some kind of general principle or something. But the law says a merchant or merchant's agent or employee who detains or causes the arrest of any person.
Objection.
Sustained.
What law you will be required to use in this case is going to be given to you directly from Judge Grady. I'm certainly not trying to tell you something that I don't believe to be true, but he's going to be the one to determine whether or not that law is applicable in this particular case. We would submit that the evidence is going to show that Taz did not act with malice. He didn't want anybody to be hurt. He was trying to do all he could. You will see video that shows him holding the knife way back to try to keep it out of the way while this struck him. And it wasn't until it became apparent that he needed to cut the straps loose that the knife even came close to Mr. Garrity. And you will also see in the video that what is happening is that Mr. Garrity is trying to pull that bag away and is pulling Taz with him. Taz will testify that he never wanted to hurt anyone. He certainly never intended to kill anyone. To begin with, all he wanted to do was to get the bag, especially when he thought that there might be a gun. And Mark Garrity wouldn't give it up. And the evidence is going to be that Mr. Cowles came down and he joined into it, and they were in there, and it's not that he was trying to break it up or whatever. He was also telling Mark Garrity, give up the bag. Drop the bag. But Mark simply would not. And there's also a fundamental difference between just shoplifting something and trying to take somebody else's property back. We would submit that when Taz did what he did what he had to do. When Mark Garrity at the end was charging him, and when Mark Garrity was fatally wounded, he was attacking Taz. Taz was in a defensive position, head down, being struck in the head. You will also find out that from the evidence that Mark Garrity's less than half this man's age. You will also hear that before he went to work late that day, Taz was having cancer treatment and was receiving intra bladder treatment for bladder cancer, where he had to go to the doctor's office and be catheterized and infused with chemicals to kill cancer. And that has effects. Bear in mind, when you are receiving all of this evidence, that is the state of North Carolina and not Taz who has the burden of proof. Not only would the state have the burden of proof beyond a reasonable doubt that Taz did something unlawful or illegal, they will also have to prove beyond a reasonable doubt that when he did what he did, he was not acting in self-defense. And again, Taz has no obligation to prove his innocence. As you were informed in jury selection, some of this evidence may be heartbreaking and difficult to see. I suspect everybody would give anything they had not to be here, not to have to go through, not to have to see what will be stated, and not to have to make the decisions that need to be made. But as all of you have indicated, that you understand that it is your civic duty to do this difficult task and to render a valuable service to the community. We believe the evidence will show that Taz was where he was supposed to be, doing what he was supposed to be doing. He was not looking for trouble, but trouble came and found him, and Mark Garrity came in to steal. After you've carefully considered all of the evidence and listened to the law that's been instructed to you by Judge Gregory, we will ask that you then return a verdict not guilty. Thank you.
All right. Thank you, Mr. Newton. Thank you, Sheriff. All right, ladies and gentlemen, we are going to take our break now. We're going to come back and begin with the presentation of evidence. Once again, please do not express an opinion, do not form an opinion, do not discuss the case. We'll come back at 11:45 to begin with the presentation of evidence. Everyone else remains seated while the jury leaves the courtroom. You'll leave your pens and pads and your chairs. See you at 11:45. Everyone else remains seated.
Okay, so this is actually not a live case, so we're just watching a bit. So I'm hoping that we can be able to skip. We're going to be able to do all of this and see what is next. Because I don't think they do come back, but they don't have much longer on this specific video that we are watching. So let's just jump back forward. Otherwise, we're just going to carry on and give you a brief summary of what happened next. And then we're going to see the next video because we do have a testimony of one of the, from day one of the employees of the convenience store. So we're just making sure that on this particular video, they do present any case that we can see, but I don't think so. So we're just going to jump on now to let me grab the name of the guy. Nathan Cowles is a former employee of the convenience store of Zarka, that he was present at the time that this happened. So he described the chaotic scene that began after the victim, Mark, was suspected of stealing. There was someone that testified before him, but we don't have that video, sadly. So the one that testified before Nathan was Bradley. There was also a witness who saw the incident occurring, and then he testified that people were just stood around filming, but nobody helped the victims. Basically, like, I don't know if you guys have seen the case out of that woman that literally sadly went up in flames in the New York subway, that people were stood around and not helping, was exactly this way. So we'll listen to what Nathan had to say and go from there, because it's going to be court TV style, so it's going to have some interruptions, but we'll try to move them along. I will try to get out my thing out of in front afterwards.
You have occasion to deal with people who might be concealing items or stealing things from the store.
Sure.
Did that happen a lot with you?
Yeah. I mean, it happened frequently.
When it would happen, was there some sort of thing that you were supposed to do as you understood it, or how did you handle those situations?
Usually, let me think about that. It depends on the situation, but predominantly, I call police.
Okay. On occasion, would you stop somebody and say, "Hey, you stolen something"?
Verbally.
Okay. Would you ever attempt to physically restrain anybody in the store?
Myself, no, never.
On April the 6th of 2023, while you were at the store, was the defendant in the store with you as well?
That was the day that this occurred?
Yes.
Yes.
Okay. And while the two of you were there, did you notice somebody possibly taking some items?
Yes.
Okay, tell us a little bit about what you remember seeing.
I was asked to look at the security camera, and Mr. Zarka asked me, tell me if somebody's putting something in their bag or if they're taking something. And I noticed that somebody had opened up a bag and taken a drink and put it inside the bag. And I said, put a drink inside the bag.
Okay. And you let the defendant know that?
Yes.
And when you let the defendant know that, what, if anything, was his reaction?
He said, handle the register, which means my job is to stand behind the register and make sure that nobody's back there. It's just my normal duties as a cashier is to be there and look around me and know my surroundings, make sure people aren't taking things, help customers, just, that typical.
Okay. At some point in time, does your attention go away from the ladies who are in front of the register and back to the defendant and the man that you saw with the drink?
Yes, once they had gotten behind the counter, their altercation, the noise that they were making had gone behind the counter, and some of the drinks that were stacked up had started to fall over, meaning somebody had hit that. That got my attention. So, I'm supposed to keep people away from the back counter, so I went over there to try to separate them.
All right. So while they're in front of the counter, or do you see when they first start talking to each other or having an interaction?
No.
Okay. Do you hear anything from those two people, either saying anything initially?
I can hear Mr. Zarka telling him to open the bag.
Okay. And do you hear anything from the other person?
At the time, I can't remember if I heard anything. It wasn't decipherable. They were a distance away from me.
Were they talking, or were the voices raised, if you remember, they being the defendant and the person he's talking to?
The open the bag part, that was clear and that was loud. I heard that.
Did you hear either one of those people make any threats to each other at that time?
No, sir. I hear Mr. Zarka telling him to open the bag. I hear Mark say something about he's got a knife. And I'm saying just give him the bag, just give him the bag. And then it turned into something else.
Okay. Well, I want to walk through that a little bit more.
Okay.
When they're at the end of the counter, you hear the defendant saying, open the bag.
Mm-hmm.
You say Mark, did you know that person at the time?
No.
Is that the person that you are referring to with the drink?
Yes.
Okay. You later find out that's his name?
Yes.
And how did you find that out?
Yes.
At some point, did that situation at the end of the bar escalate even further?
Mr. Zarka went for his bag, to take his bag.
Tell us about that. What happened that you saw?
So, I don't really remember much of it. I just remember something hitting my hand and looking at it and seeing blood. And I knew that I was stepping back at that point in time.
Okay. So did you get cut?
Yes.
All right. And when you stepped back, did you keep watching what happened? Or what did you?
No, I turned my attention back to the register because I said, I'm out, I didn't say anything. That was what I was thinking was, I don't get paid enough to stand around and get stabbed, So I went back to the register.
Okay. At some point, did you see what happened in the front door? Did you see that? Did you see Mark stay or leave, or what was going on, if you remember?
I glanced up and saw him going out the door.
Okay. At some point, after he leaves the door, leaves out the front door, do you remember what the defendant did?
Told me to call the police.
When Mark left the store and it's just you and the defendant are in the store still, correct?
Yeah, I don't remember if there were other people around.
Okay. Other than him telling you to call the cops, did he make any statements to you?
No.
Did he indicate to you that he was scared or that he felt that he had to do it or anything like that?
No.
How would you describe his demeanor after it all happened?
Normal.
Okay, so this witness certainly adding some perspective, some context to the situation
we're
that's in
gonna
question.
Skip. I think that's pretty much it. That's sadly the what we have from this witness. Like, again, there's not a lot available because this was a case that was not as big as other cases that were at the time, or Court TV decided not to stream as a normal case and just did this little bit of information that we have. But on my notes of after investigation, sorry, excuse me, I was eating a sweet while it was testifying. I did not know it was gonna end that fast. Give me 1 second. Apologies. So anyway, after this, I'm gonna be talking a bit now because there is not a lot of videos now from day one. There have some notes of what happened from investigation from Court TV website and some other websites that were following this case. So I just compile them and make my own notes, and then we'll move on to the next video excerpt thing that there is available. Yeah, it's just quite easy. But thank you, Kay. Appreciate that. So after this gentleman Nathan, there was a detective, Justin Wester, that showed the jury Mark's Garrity's backpack. So Mark is the blue green-eyed gentleman that is on the screen right now. That is our victim. So inside of that backpack, there was a bottle of blue Gatorade, and that Garrity's tried to shoplift by putting in a bag. Then there was a witness that she filmed the whole incident in the and instead she filmed the whole incident, and then she was giving a play by play recall of the events, but the judge deemed that witness that filmed the cell phone video that we will see saying that she was a hostile and adverse witness because all that she responded from every question from the prosecution is, "I don't remember." So like she was like, "I don't remember, I don't remember, I don't remember," to every single question that the prosecution was saying. So then afterwards we had, this was also I forgot to mention, this was a very speedy trial. Even though it was 6 days, it was quite speedy, and you guys will figure out soon why. After that, ODME testified that as we heard in defense openings, that Garrity Mark had drugs in the system, cocaine and fentanyl, and then there were significant level of drugs. They determined that did not cause the victim's death, so it did not die as an overdose or anything like they could have said. And then he said that the cause of the death of the unaliving was the 3 stabs wounds that was associated with the blood loss. And then that was day one. Day one was recapped. Now, day two. Day two started with the jury seeing the footage showing the incident encounter between the defendant Taz and the victim Mark. So, what we're gonna do, I do find 2 different angles that they were mentioning of the video. So we're gonna play one, and then we're gonna try to play the other one. So they are brief videos as well. So let me go back and and then just do this and share again, because when I jump between windows, the sound sometimes doesn't go with the windows. So here we go. It should be almost ready, and hopefully this is one of them. Some of them, they don't have a sound, so
Oh, that's right there on the way.
So this part is a little bit unmuted. You can see in the corner. So they literally fighting right now, and they were in a corner, and people standing around and not doing anything, and just yeah. If the cameraman would just show the video and not the Taz, I would like to watch the video.
Oh my God! He's down there! He's down there! Oh my God! Oh my God! He's down there!
Good. I'm gonna ask that if the purpose of the introduction of this was, as was stated in the bench, that there was conversation that can be heard, that event is over. And any further playing of this does not add any additional probative value whatsoever, and is just likely to further inflame the jury.
You be heard.
Only to clarify, I didn't say that at the bench. However, I was about to stop the video anyway, and so I'm going to stop the video at 1 minute and 54 seconds for the record.
So noted. You may continue with your examination.
Detective, after all of your investigation was completed in this matter, did you make a determination that you would charge the defendant in this case?
Yes, sir.
Thank you. I don't have any other questions.
Cross
No, Your Honor.
is, I know Detective Heffman's your lead detective, but for the purpose of the record, is he under subpoena?
He is.
Are you asking that he be released?
I have no problem with that.
Any objection?
He is the lead detective, and if it is determined at a later time, he is the lead detective in this, and if at a later time I may want to call him, I'd ask that he remain. I assumed he would anyway.
Detective, I'm going to have you remain under subpoena.
Yes, sir.
Thank you, sir.
Yes, sir.
All right. The state may call its next witness.
Your Honor, the state of North Carolina rests.
Ladies and gentlemen, as a function of that, I have to deal with an administrative matter outside of your presence. The district attorney has informed the court.
All right, so they were a little bit ahead because on the investigation they did show twice the video, day 3 and day 2. So that was a bit of day 3 where you just heard that the prosecution rested. And then normally the prosecution does rest after the lead detective testify. And hello, Toxic, or is it Banshee? I hope Toxic is okay. Keep thinking of her. Hopefully she is doing better. Please let us know how she's doing and give her our love and the speedy recovery as well. But also, like I was saying, we have the other angle of view of the video. It is basically the same that we just saw, but Core TV with this case, they did a recap of the day 2. So what we're gonna do is watch this, and then I'm gonna talk about the bullet points that I have on my notepad about it. So I'm gonna share this one.
He tries to get out.
Oh, it's a little bit loud on my ears. And we're going to watch this one, and then we're going to talk about day 2 of this case after the recap, watching the recap.
Out of there, and it gets physical. And at that point, the defendant takes that knife, and it's clear at this point that he stabs him several times. He stabbed, the doctors are going to tell you, 3 times at multiple depths inside of this person. 2.5 inches, 3.5 inches, 4.5 inches. One of those straight to the heart.
We've got the convenience store homicide case. Defendant Taz Zarka is the accused. Now, it's expected to resume in about 30 minutes from now. Welcome to Court TV Live. I'm Julie Grant. So this guy is charged with second-degree murder for the stabbing death of a customer in his convenience store. The man who's deceased is Mark.
Even though I do like Julie Grant, we're gonna skip her. Then are all you guys want to watch, because it will give a bit more context about what exactly is happening. We can watch what she's saying and then comment on what on things that happened. I do like her. She's good. She well, obviously she knows what she's doing. She's been doing this for quite a while. So we're just going to carry on watching her and then we can comment.
Garrity Jr. The incident happened in last year in April. Zarka claims that he stabbed Garrity in self-defense after they got into an argument over an alleged stolen bottle of Gatorade. Let's take a look back at the best moments from Thursday.
When I got there, I saw droplets of what appeared to be blood on various things such as the plastic bags, the front counter, the floor appeared to have streaks, red streak marks, and it appeared that it had been mopped.
Did mopping up the floor in any way, shape, or form detract from the collection of evidence in the store?
No.
And on his shirt, did you notice anything on his shirt?
It appears that there's areas of similar appearance to blood. He had a Band-Aid on his right thumb and his left index finger.
I've always had a professional relationship with him. He had attempted to shake my hand, to which I declined, not trying to be rude, but there was blood about his person. He stated at one point when I first arrived on scene that he was trying to be a tough guy. I think probably implying the deceased, who was no longer on scene at the time.
Referring to that individual, he said he was trying to be a tough guy?
That's correct, sir.
One thing that you wrote down in your report that Taz said that Mr. Garrity, the other person in the incident, was trying to be a tough guy.
Yes, sir. Any statement like that, I want to be presented to an investigator to properly document it.
Any bruising, swelling, bleeding, cuts, scrapes on his head and face?
On his head and face, no. As we saw, he did have a couple marks on his hand, but on his head and face, I don't recall seeing anything.
When you watched the video, were there other people in the store when the stabbing happened?
Yes, sir.
Were you able to identify those other people?
Yes, sir.
During the course of the investigation, did you learn about Anaya Rogers and a possible cell phone video?
Yes, sir. She recalled seeing the victim going to an ice cream cooler, and at some point, Mr. Taz approaching the victim, as she described, with a knife out, quote unquote. She initially thought that he was pulling the knife on her.
Did she describe what happened, if anything, when the defendant got to the victim with the knife?
She described Mr. Taz jamming him up, quote unquote, against the table.
Okay. Did she make any statements about the defendant and how well he gets along with a lot of people?
Objection.
When you spoke to her, did she make any statements regarding the defendant and his interactions with other people?
She did make a statement that he fights a lot of people.
Did she make any statements about him ever cutting bags before?
She did. She said that he has cut one of her bags before on a previous occasion.
Did she say why she believed that he had cut her bag?
She indicated that Mr. Zarka believed that she stole some chips and cut her bag as she was walking out of the store.
All right, what do you think of this case? Really, the only question is whether this homicide was justified, right? So when you have a case like this, we know that one person killed another person, right? So this is a homicide, but not every homicide is illegal. Some of them are justified. Some of them are accidental. Some of them are murder, and they are illegal. And that is the contention of the state of North Carolina. If you're wondering, this trial is happening in the Raleigh area, capital of North Carolina. Let's bring in our legal analyst guest and talk some more about what we've seen so far. Criminal defense attorney and former prosecutor Joe Tamburino on the show today. Joe, okay, give us your...
Skip this part because, like, we would love some expert opinions, but we're not here for facts. We're just here to know exactly what happens and then when the went up. So that was their recap of day 2. Now I'm going to do my own recap of day 2 of what happened in this case. So we've seen throughout the video that they showed videos of Zarka pulling out a mop and mopping the shop floor and the store after he was stabbed, and he was outside bleeding in the street. And instead of trying to help him, because yes, if it was a self-defense, you wouldn't feel bad that you did what you did, and you would probably help the person not to lose their life and try to save it. But now he was more concerned of cleaning the shop floor than actually helping him out. Then the jury, and sadly we won't be able to watch the police interview in which Zarka said that he was swung his knife just once at Garrett after Garrett punched him and had kicked Zarka. So in the police interview, Zarka also expressed shock and regret over learning of the death of Garrett, a statement that drew gasps from Garrett's family and then supporters in the courtroom. I think it was always hard to be there. And then, as we saw at the end, towards the end of their recap, they were the lead investigation, the detective Eric, the video that was a bit contradicted Zarka's testimony and what he had said in the interview. So it was a lot of discrepancies between those two statements. Then there was a downtown hospitality officer, Jackson, that testified that after the incident, the defendant said that the victim was trying to be a tough guy, which is just anyway. And then there was several other people, as we saw, that testified that day. Day 3, it started, and obviously, as we saw previously, they did rest on day 2. On day 2. So day 3 started with the defense case. The defense case started with, because it was a self-defense claim, Zarka basically has to testify to tell his account of the events, like we saw, for example, in Sarah Bourne's trial. So because it's a self-defense trial, he has to testify to present his case, and he has to present a case to say that it was self-defense. So there is actually, which I am very happy about, and I hope it is the full testimony of Zarka in the stand, and that we are gonna be watching now. So I'm gonna play. I could have had this, but I think he starts almost straight away, so we're gonna just watch that now.
I do. Well, you can see yourself.
Thank you, Sheriff, and thank you, Madam Clerk. All right, sir, if you will state your first and last name for the record.
Taiseer Zarka.
If you will spell your first and last name for the record.
First name Taiseer, Taiseer. Last name Zarka, Zarka.
And so thank you for keeping your voice up like you're doing. Just be mindful of the fact that the court reporter is taking down everything you say. So please try not to speak too fast. And finally, if you'll allow for the attorney to ask the question, then you can respond in order to avoid talking to each other, okay?
Yes, sir.
All right, this witness is with the defense.
Thank you, Your Honor. Mr. Zarka, everybody seems to call you Taz. Do you have any problem with me referring to you that way?
That's okay, sir. That's fine.
Taz, where were you born?
In Gaza Strip, Palestine,
And when were you born?
January 19th, 1963.
How old are you now?
61. This coming January 19th, I'll be 62.
How old were you on April the 4th of last year?
61.
Mr. Zarka, how tall are you?
About 5'9", 5'10".
How much do you weigh? Well, how much did you weigh in April of last year?
Approximately 170, 175 pounds.
Do you have any health issues?
Yes, sir.
And what are your health issues?
I have bladder and prostate cancer.
Okay. In April of 2023, were you being treated for cancer?
Yes, sir.
And were you receiving chemotherapy at that time?
Yes, sir.
And how did they do that?
Don't know the exact English word, catheter or something like that, but they inject chemical, liquid chemical.
And did they do that at your doctor's office?
Yes, sir.
And would you have to stay at the doctor's office until that was completed?
Yes, sir.
Did you have any effects of the chemotherapy that you were being given at that time?
It doesn't have an effect after.
Right. And how would it affect you?
It hurts the joint mainly in the bones.
Did you receive a treatment for your cancer on the morning of April the 6th of last year?
Yes, sir.
And as a result of that work, when did you go into work that day?
Yes, sir.
And when did you go into work?
I can't remember exactly what time, but it was in the afternoon, after 1 o'clock.
What kind of work do you do?
I own a convenience store, retail business.
That the store that's located at 207 South Wilmington Street that we all visited a little earlier this afternoon.
Yes, sir. That's a supermarket.
How long have you been in the convenience store or supermarket business?
Well, straight up for almost for the past, going into my 25 years. And before, when I was a student, I was also in retail business.
All right, well, let me ask you some things about your background, if I could. You indicated that you were born in Gaza and Palestine in 1963. Did you have an occasion to leave Palestine?
Yes, sir. Because of the circumstances, my dad moved us to Kuwait. My dad was the head auditor for the Ministry of Education in Kuwait.
And how long did you live in Kuwait the first time?
Until, I think, 1980.
In 1980, where did you move?
I came to Raleigh, North Carolina.
And why did you come here?
To go to college.
When you came here, where did you go to school?
My first semester was at Shaw University, downtown Raleigh.
Okay. And then can you tell me where else you went to school?
I went for almost a couple of years at East Carolina University in Greenville. And I went for a couple of years for associate at White Technical College. Then I went back to Shaw University and finished a double major in business management and accounting.
When was that?
I think in 1987, 1988.
Okay. After you finished college, what did you do?
I went back to Kuwait to be next to my family. And I worked in Kuwait for almost 12 years.
What kind of work did you do in Kuwait?
I worked in two fields, the field of shipping and logistics and in the trading business.
And for how long were you in Kuwait for that particular time that you were there?
Almost 12 years.
So, were you in Kuwait when the Iraqis invaded Kuwait?
Yes, sir. Desert Storm, I was in Kuwait.
And how did that affect you?
Objection. Oh, sustain.
During that period of time, did you provide any assistance to Americans who were living in Kuwait at the time of that invasion?
Oh, sustain.
Council did not state a basis for the objection.
Relevance. Sustain.
Mr. Zarka, did you stay in Kuwait through the duration of that conflict?
Yes, sir.
And did you continue to stay in Kuwait after that?
Yes, sir.
Were you doing the same things after the invasion of Kuwait that you did before?
Yes, sir. When the invasion of Kuwait happened, after I was still in the logistics and the shipping business, and that's where my service is much needed.
Okay. What kind of logistics and shipping were you doing at the time?
Well, anything you move by air, ocean, or land, I could do it for you. And especially after through the contract which we were helping the
Objection. Well. Mr. Newton and Mr. Latour, if you will approach, please.
All right, Taz Zarka, 61 years old, born in Gaza, was in Kuwait in...
Okay, so now we're gonna skip. It's I understand it's a bit I work in retail. My day job, called day job. My main job is I work in a retail. I work in a shop like a Walmart, Target, all those chains. I work that's over here in the UK. And it is hard when you see a shoplifter in the store and not step in and having to stop yourself and not stopping. So this kind of hits a bit closer to me. I understand this side, but I also understand the human side of, okay, you were defending yourself, but you then could have give him some assistance of after you stabbed him. You could have do a little bit of first aid or call an ambulance or ask someone to call them, because there is self-defense and then there is not being a human being. Him after, because there was already testimonies after that incident occurred, he could have literally just helped him and tried to stop the bleeds on or whatever, to try to help him, and not leaving him on outside to lose all his blood and die. So true that, yes, it is hard. It is so very hard when you're working in a shop, and even if it is not and it's not my own, I don't own the chain, and he owns, so his pride and his love for his work and his place is even bigger than mine and the care. So I understand his side. That's like, it's hard to see other people shoplift, and when you have to work so hard to be able to afford groceries, and some people just take for granted and just go and take whatever they want whenever they want, and that's not fair. That is not fair, and it is not. But sadly, it's a fact of life that happens. But then there's self-defense, and there is not caring for another human being, and then being a charge of second degree unaliving, and that's what he's facing here. And he could have been, yes, it is self-defense, but self-defense went out of the pocket, in my opinion, because he could have called the police. He could call and the firefighters, the ambulance, and he could have also tried to stop the bleeding. Because I mean, you're gonna say that in your convenience store you don't have like a first aid kit or some paper towels to stop the bleeding, towels even. So he could have done something, even though he felt bad for it. He could have done, but no, he was mopping and carrying on as business as usual, like nothing has happened. So I'm sorry, sir, but your self-defense, in my opinion, obviously, your self-defense defense went out of the bag. But let's carry on watching the defense and stop hearing myself talk.
Let the record reflect the majority of the courtroom. Yes, sir, Mr. Nixon.
I'm seeking to elucidate from the defendant, who is the most crucial piece of evidence on his behalf for his defense. Inquiring into his background, his development, his life experience as a human being, as that may relate to the development of his character, his reputation, and ultimately his credibility with this jury in terms of whether they want to believe him or not. If I need to ask more so that we can have a proffer so the court can understand what the questions were and what his answer would be to those, I would like to do that.
That'll be fine. The reason why the court had a concern, there was an objection, and I sustained it. At one point, I believe you asked him about the war and what he did to help Americans during the war. There was an objection. I sustained it. I did not think it was relevant. But do you need to be heard first before a potential proffer?
I don't
on the record.
I don't mind if he gives a proffer. Obviously, what we discussed at the bench was this very thing, that it appeared that he was attempting to elicit history about this defendant and his assistance in a war in the 90s. I don't know how that is relevant to what occurred on this occasion some decades later. And I would argue that the probative value of that is outweighed by any attempt to just ingratiate him to the jury to seek sympathy for what he has experienced in the past, rather than his actual state of mind at the exact moment of what occurred, which is what is at issue in this at this moment.
What I would do, Mr. Nixon, I'm going to allow you to make a proffer.
Thank you.
Yes, sir.
Mr. Zarka, can you tell me about the experience and what happened with the invasion of Kuwait and what you personally did in the course of that period of time?
Our country was down in 48 hours. It was a big chaos. All nationalities were trying to run out of the country, either through airport, and it was a very short time for people to escape, some by land. There was no way to go by sea through the Gulf. So either they go north, which is Iraq, and they're not going to go north because the Iraqis were coming down, Kuwait is the south part of Iraq, or go to Saudi Arabia. From a personal level, I did my part, and from a professional level, I did also a great part to be there to the American civilians, or even to the American Army at the first American base in Kuwait called Camp Doha, through my shipping and logistic career.
What did you do personally to be of assistance?
On the personal level, the Iraqis, I don't know, it was order from the army or a personal movement. They were trying to capture any foreign identity, English, French, Americans. And in Kuwait, we had American University and we had American High School. And I managed gracefully to, in a small minibus, to make almost 40 trips to take American families with kids to the Saudi border and come back. And it was unfortunate the last trip because one of them had left his passport in one of the seats. And when I get from the Saharas, from the sand to the main road, at the checkpoint, they checked the car, they found the passport. And I was actually physically, for almost 4 to 5 days, I was hanging with one arm. That's why I still have dislocated arm until now.
And is that injury to your arm something that affects you today?
Until now, yes.
In your the service with your logistical company, who was that service provider?
I was a manager at number one freight forwarding company called the biggest group of the Gulf called Al Industries. And at that time, after the liberation, the American Army started the first base in Kuwait called Camp Doha, DOHA. And because of my American degree and me knowing all the formalities and the procedures in land, sea, and ocean, I was handling almost 75% of anything our army had imported to Kuwait, from a match to airplane spare parts. And I will make sure that everything is cleared, properly delivered, also through the customs, from any of the entries of Kuwait to go to the warehouses for our army in Kuwait.
All right, thank you, sir. That is the testimony that I wanted to elicit from that period of time, and is in Kuwait. And
you're just joining us. The jury has been excused so they could do a proffer to determine by the judge what evidence comes in or not. And Michael, this is his background, and the defense says, well, that builds to his character, reputation, credibility.
Of information of what's happening, and just because it's easier than I've actually everything to happen, I was gonna attack Kay with yes, there was Nick Mew, that case that you were mentioning about the rafting trip case, that it was being harassed by some teens. Yes, the teens were in the wrong, but you just don't go stab people just because of it, even though they are annoying you and being annoyed. You remove yourself from the situation. You go away, you move along, you go back to your party, you go back to your friends that you were there with. You just don't start doing that. It's like if it was, you just remove yourself from the situation. And where I work, they say that we can't even chase shoplifters. We can get in big trouble because of that, because it's better to be safe in be safe and go home to our families than to them having to make the call that they don't want to make, saying that something bigger happened. So it's always best to remove and not involve in a situation. I understand people nowadays are very scared of getting themselves involved in something that is happening, like for example if you see something. But that's the thing, you don't have to be the superhero and involve yourself in a situation. You can just call 911 or the emergency contact that it is in your local area and report the situation. And if you can do something about it, as long as you are safe, yes, do it. But if you're something that you're not going to be safe and you are scared, call 911 straight away. You should be able to get in and get through to 911 straight away and not having to even wait. And it's not like you're going to be calling um parents or friends or anything. So it's just, I think, if you're not comfortable of getting yourself in a situation, like if you see something happening in the streets or in the shop or anything, you don't need to get yourself involved. You can call 911 and they should be coming immediately, because if it is definitely an emergency, they will come immediately. So, and sometimes it is not worth it to be in a situation and just, yeah, call on the, yeah, no, because we don't get involved the retails, because it's not worth it. My life and or anyone's life still works in a supermarket. It's not worth it to stop junkies or people that are literally horrible stealing. It's not worth it. I want to get home from my husband. I want to get home from my life. I want to be with my friends. I want to do my things. I don't want to have to stop my life because of someone that decided to just, oh, let's just shoplift. And now even in California, it is a felony to shoplift. It literally from I think the beginning of this year or at some point last month, it is now a felony in California to shoplift. And there was actually a funny video about it on the YouTube the other day of the two girls that shoplifted, and they were arrested and they got told that it's a felony, and one of them did not know that now in California it's a felony to shoplift. So there you go. Now you literally can, yeah, you can exactly be held liable financially, emotionally, physically, and especially in the US, you can sue anyone for anything and for any reason. Yes, definitely. I agree. So that's why people don't really get involved, and they shouldn't be fail. But you can still do something about it. There's still 911 that you can call about, or if you don't want to call 911 for some reason, well, ask somebody to do it. It's a dial. It's talking. You don't even need to give your name. You can call 911 anonymously. You don't need to give your name or your details if you don't want to. Just do it anonymously. But anyway, let's carry on with the trial and finish off to listen to the testimony. And yeah,
elicit this testimony and evidence for the purpose of establishing this man's credibility and for the purpose of establishing that he is a good man. And I believe that his background and experience such as this is completely relevant and should be admitted.
Him being a good man is not what is at issue in this case. His general character has been testified to by 5 witnesses about peacefulness. This testimony has nothing to do with his ability or his reputation for peacefulness in this community. The only thing that I would argue and would concede is likely relevant from this information is that he has an arm injury or had an arm injury. I think he could testify that if he suffers from any ailments, just as he did with the cancer, which I am very sad to hear. But that, I didn't object to that. I would not object to if he testified, I have an arm injury that bothers me to this day that I suffered during my time that I lived in Kuwait. But this whole history of his logistics and saving children, which may be admirable is not relevant for anything that this jury has to decide in this case.
All right, thank you. The court is going to indicate that first, as far as the temporal, the time between the date of this offense, which is April the 6th of 2023, and the invasion of Kuwait, I think the DA said the 90s. I'm not a history buff, but that being the case, the time, first of all, is the relevance as far as what happened then and the offense date. I don't see how him assisting, I believe he said some Americans, maybe 40 trips to the border, that being the Saudi Arabia border. I don't see how that's relevant to this matter. I do agree that he mentioned his injury. I will allow for him to testify about his arm injury, but not as to how it occurred and when it occurred, as far as dealing with the war and so forth. He can indicate, yes, I suffered an injury and I had an issue with my arm. It was dislocated. And if he said it bothers him to this day, if that's what the testimony will be, that's fine. But to indicate to this jury that he's allowed to testify about what he did or may not have done in Kuwait, because this is respectfully what he is telling or wants to tell the jury. I have no indication other than what he's telling, or would like to tell the jury. I have no indication of the veracity of that, but more importantly, as to the relevance of that. This case is about second-degree murder. This case is not about what he may or may not have done to assist Americans during the invasion of Kuwait and Afghanistan. It's not about that. I don't see a relevant line that he can draw other than to ingratiate himself to the jury for sympathy, indicating that based on what he says, he's helped Americans in the past. That's admirable, but that is not admissible. Therefore, the objection is sustained. All right, and I'm assuming you're objecting to my ruling, so noted for the record. Anything further from the state?
No, Your Honor.
Mr. Weeks?
No, Your Honor.
All right, we can bring the jury back.
Yes, Your Honor.
All right, so Judge.
So, we were having that discussion. Stores, what I know, it's from like big chains, because I used to work. I still work in retail, and I used to be a store manager for a retail company over here in the UK. And I know for experience that they have insurance that are, they have premiums that you can claim that money back of the goods that are the stolen goods from a shop, and obviously they have to pay the premiums and everything for it, but they can just claim that money back as fast as they lost it, as long as there's obviously cameras that shows the event, there's reports about it, and then there is, if necessary, there is a police report made about that situation. That's, at least that's how it works over here in the UK. I don't know if works the same way over there in the US, but at least that's why companies say to staff members, do not chase them, not even inside the store. You should stop them. Just make sure that yourself and other people and other customers and other colleagues are safe, and that the shoplifters do not stab you, prick you, do whatever can be done. It is tough. Oh, it is tough for sure to watch that happen. I've watched so many shoplifters, so many so many things that has happened in my 10 years that I've been working in retail. And it's hard because you have pride and you have joy in what you do and in your store and everything. And it is hard just seeing someone coming in and take that for granted and take it out. And it's hard. But yeah. But anyway, yeah, if like it is going to be hard for him in prison if he does get convicted or anything, but but I mean, it is the consequences of your actions. Yeah, let's carry on then. Oh, no.
Mr. Zarka, without telling me how you sustained the injury, did you sustain an injury to one of your arms when you were in Iraq and in Kuwait?
Yes, sir. My right arm.
And what kind of injury did you receive?
Dislocation.
Okay. And does that injury still cause you problems to this day?
Yes, sir.
Why did you decide to come back to the United States from Kuwait?
Just for better future for the kids. Getting away from the war zone.
How many children do you have?
I have 3 beautiful children.
How old are they?
I have a son, he's 28 years old. And a daughter, she's 24 years old. And a daughter, she's 8 years old.
I take it the older children are grown up and they do not live with you?
Yes, sir.
Do you share custody of your 8-year-old daughter?
Yes, I do.
Now, when you decided to come back to the United States in 2000, did you come back to the United States in the year 2000?
Yes, sir. I came back to America in the year 2000. I had a good job offer to work for a shipping company up in Baltimore, Maryland. And also the same year, 2000, there was a very big international kind of examination that the Canadian government they do. And they actually granted me a landing, which is also kind of residency in Canada in the year 2000 to join the Canadian Chamber of Commerce over there due to my experiences.
And why did you decide not to go to or stay in Canada?
Stockholm.
So when did you moved into Raleigh at sometime in 2000, is that correct?
Yes, sir.
What kind of work did you do when you finally came to Raleigh and settled into Raleigh?
I had the choice to go back to the corporate world or just to be on my own. And I studied the market, what is the best implementation for supply and demand, and something that I can deal with people. And I really found it in retail. I mean, everybody goes to the convenience store. Everybody always wants something. It's recession-free. And I mean, less danger, better than restaurants. And also, I like it. I like it dealing with all kind of people, races, you know. You get to know a lot of people.
Did you just open up a store, or how did that happen?
Yeah, after I made a decision that I want to be in retail, I got into the gas station business and convenience stores.
And did that start with one store?
I started with one to a point of time in downtown Raleigh. I had 4 of them.
Okay.
Yes, sir. But now, I guess I'm getting older. I can't handle the pressure anymore. Too many hours.
How long have you had your store at 207 South Wilmington Street?
I think this one, to do the license for it to open in 2007, 2008.
And so 16, 17 years?
Yes, sir, this location, but I had other location before it on South Wilmington Street also.
Okay. How long had, Mr. Philip Horwitz, who testified a little while ago, how long have you known him and how long has he been a landlord for you?
Over 20 years, 21, 22 years.
So was he a landlord at one of the other locations before you
Yes,
opened
sir.
to us?
Yes, sir.
All right. Tell me about the store. I know the jury has seen it, but when is it open? When does it close? What do you sell, and what do you personally do there?
Yes. I'm open 7 days a week. During the weekdays until 12 o'clock. On Thursday, Friday, Saturday, we stay open till 2 o'clock in the morning. But we open 6 a.m. every day. And I merchandise everything as much as I can, have the variety of all kind of drinks, soft drinks, juices, sundries, candies, house supplies, tobacco products. Have the best beer selection in town, the best wine selection in town. I try to be picky.
What kind of hours did you personally work at the store?
Oh, yes, sir. Until really started feeling really bad with that cancer. I'm there every single day. This is my schedule. 5 o'clock I'm up, shower, do my morning prayers. 5:30 I'm in downtown. I lock the door behind me, get the fresh coffee ready, turn my radio, my favorite radio station on, and 6 o'clock sharp, the sign is open. 6 o'clock in the afternoon, 7 o'clock in the afternoon, I'm out of the shop.
Okay, do you have other people who work for you?
Yes, I do.
Now, in doing the business that you do and dealing with general customers, excuse me, do you have problems with people shoplifting or stealing items from you?
See, sir, I am a public business, and we get them all. I mean, I'll be behind the register. At the same line, there'll be an engineer, a DA, a homeless, a thief, a breacher. You know, downtown is a collective area. It has everybody. People come to visit downtown, people come to course in downtown, people come. I'm very close to the main bus station of the capital of the state of North Carolina. So that's a foot of traffic. And everybody, a lot of people ride the bus regardless of what their job description. And I serve all. I average almost 600 to 700 walk-ins a day, over 20,000 a month. So I get them all. You know, I'm a high traffic store.
How often?
All right, joining us on this Friday, as always, for our
So on that day, the where Zarka was testifying, the judge did finish the day early because the defense attorney was having a cough attack, and as out of cautions and carefulness and regard for the defense attorney, the judge did end the day early. I do have another video of the testimony, which looks like there is no interruptions whatsoever on the thing, but I don't know if they have the proffer or not. We can listen and just see what happens with this one.
Yes, sir.
And would you have to stay at the doctor's office until that was completed?
Yes, sir.
Did you have any effects of the chemotherapy that you were being given at that time?
It doesn't have the effect after.
Right. And how would it affect you?
It hurts the joint mainly in the bones.
Did you receive a treatment for your cancer on the morning of April the 6th of last year?
Yes, sir.
And as a result of that, when did you go into work that day?
Yes, sir.
And when did you go into work?
I can't remember exactly what time, but it was in the afternoon, after 1 o'clock.
What kind of work do you do?
I own a convenience store, retail business.
Okay. Is that the store that's located at 207 South Wilmington Street that we all visited a little earlier this afternoon?
Yes, sir. That's the supermarket.
How long have you been in the convenience store or supermarket business?
Well, straight up for almost for the past, going into my 25 years. And before, when I was a student, I was also in retail business.
All right, but let me ask you some things about your background, if I could. You indicated that you were born in Gaza and Palestine in 1963. Did you have an occasion to leave Palestine?
Yes, sir. Because of the circumstances, my dad moved us to Kuwait. My dad was the head auditor for the Ministry of Education in Kuwait.
And how long did you live in Kuwait the first time?
Until, I think, 1980.
In 1980, where did you live?
I came to Raleigh, North Carolina,
And why did you come here?
to go to college.
When you came here, where did you go to school?
My first semester was at Shaw University, downtown Raleigh.
Okay. And then can you tell me where else you went to school?
I went for almost a couple of years at East Carolina University in Greenville. And I went for a couple of years for associate at the White Technical College. Then I went back to Shaw University and finished a double major in business management and accounting.
When was that?
I think in 1987, 1988.
Okay. After you finished college, what did you do?
I went back to Kuwait to be next to my family. And I worked in Kuwait for almost 12 years.
What kind of work did you do in Kuwait?
I worked in two fields, the field of shipping and logistics, and in the trading business.
And for how long were you in Kuwait for that particular time that you were there?
Almost 12 years.
So, were you in Kuwait when the Iraqis invaded Kuwait?
Yes, sir. Desert Storm, I was in Kuwait.
And how did that affect you?
Objection. Well, stay.
During that period of time, did you provide any assistance to Americans who were living in Kuwait at the time of that invasion?
Well, sustain.
Counsel did not state a basis for the objection.
Relevance. Sustain.
Mr. Zarka, did you stay in Kuwait through the duration of that conflict?
Yes, sir.
And did you continue to stay in Kuwait after that?
Yes, sir.
Were you doing the same things after the invasion of Kuwait that you did before?
Yes, sir. When the invasion of Kuwait happened, after I was studying the logistics and the shipping business, and that's where my service is much needed.
Okay. What kind of logistics and shipping were you doing at the time?
Well, anything to move by air, ocean, or land, I could do it for you. And especially through the contractor, which we were helping the
Mr. Newton and Mr. Latour will approach, please.
Right. We'll see if I can jump on of this sidebar. Because I think that's when the prof happened about this whole situation of Kuwait. So we'll see what happens.
All right, thank you, Sheriff. Let the record reflect the majority of the courtroom. Yes, sir, Mr. Newton.
I'm seeking to elucidate from the defendant.
Okay, so they're gonna do
Listen.
the proffer thing again. Because when we were watching the core TV side of things, we could not listen to the prophet. You want to listen to the prophet, you want to just try to move on out of this one and just carry on with the testimony, because that's the thing is I don't know when he goes back to regular testimony. Think so. We just watch. We'll just watch the whole thing and see what he says about the prophet.
Most crucial piece of evidence on his behalf for his defense. Inquiring into his background, his development, his life experience as a human being, as that may relate to the development of his character, his reputation, and ultimately his credibility with this jury in terms of whether they want to believe him or not. If I need to ask more so that we can have a proffer so the court can understand what the questions were and what his answer would be to those, I would like to do that.
That'll respond to the reason why the court had a concern. There was an objection, and I sustained it. At one point, I believe you asked him about the war and what he did to help Americans during the war. There was an objection. I sustained it. I did not think it was relevant. But do you be heard first before a potential proffer?
I
don't on the record.
I don't mind if he gives a proffer. Obviously, what we discussed at the bench was this very thing, that it appeared that he was attempting to elicit history about this defendant and his assistance in a war in the 90s. I don't know how that is relevant to what occurred on this occasion some decades later. And I would argue that the probative value of that is outweighed by any attempt to just ingratiate him to the jury to seek sympathy for what he has experienced in the past, rather than his actual state of mind at the exact moment of what occurred, which is what is at issue in this at this moment.
What I would do, Mr. Newton, I'm going to allow you to make a proffer.
Thank you, Your Honor.
Yes, sir.
Mr. Zarka, can you tell me about the experience and what happened with the invasion of Kuwait and what you personally did in the course of that period of time?
Our country was down in 48 hours. It was a big chaos. All nationalities were trying to run out of the country, either through airport, and it was a very short time for people to escape, some by land. There was no way to go by sea through the Gulf. So either they go north, which is Iraq, and they're not going to go north because Iraqis were coming down, Kuwait is the south part of Iraq, or go to Saudi Arabia. From a personal level, I did my part, and from a professional level, I did also a great part to be there to the American civilians, or even to the American Army at the first American base in Kuwait called Camp Doha, through my shipping and logistic career.
What did you do personally to be of assistance?
On the personal level, the Iraqis, I don't know, it was order from the army or a personal movement. They were trying to capture any foreign identity, English, French, Americans. And in Kuwait, we had American University and we had American High School. And I managed gracefully to, in a small minibus, to make almost 40 trips to take American families with kids to the Saudi border and come back. And it was unfortunate the last trip because one of them had left his passport in one of the seats. And when I get from the Saharas, from the sand to the main road at the checkpoint, they checked the car and they found the passport. And it was actually physically for almost 4 to 5 days, it was hanging with one arm. That's why I still have dislocated arm until now.
And is that injury to your arm something that affects you today?
Until now, yes.
In your the service with your logistical company, who was that service provider?
I was a manager at number one freight forwarding company called the biggest group in the Gulf called Al Industries. And at that time, after the liberation, the American Army started the first base in Kuwait called Camp Doha, DOHA. And because of my American degree and me knowing all the formalities and the procedures in land, sea, and ocean, I was handling almost 75% of anything our army had imported to Kuwait from a match to airplane spare parts. And I will make sure that everything cleared, properly delivered, also through the customs from any of the areas of Kuwait to go to the warehouses for our army in Kuwait.
All right, thank you, sir. That is the testimony that I wanted to elicit from that period of time and is in Kuwait.
Yeah.
And I absolutely am trying to elicit this testimony and evidence for the purpose of establishing this man's credibility and for the purpose of establishing that he is a good man. And I believe that his background and experience such as this is completely relevant and should be admitted.
Mr.
Him being a good man is not what is at issue in this case. His general character has been testified to by 5 witnesses about peacefulness. This testimony has nothing to do with his ability or his reputation for peacefulness in this community. The only thing that I would argue and would concede is likely relevant from this information is that he has an arm injury or had an arm injury. I think he could testify that if he suffers from any ailments, just as he did with the cancer, which I am very sad to hear. But that, I didn't object to that. I would not object to if he testified. I have an arm injury that bothers me to this day that I suffered during my time that I lived in Kuwait. But this whole history of his logistics and saving children, which may be admirable, is not relevant for anything that this jury has to decide in this case.
All right, thank you. The court is going to indicate that first, as far as the temporal
the time between the date of this offense, which was April the 6th of 2023, and the invasion of Kuwait. I think the DA said the 90s. I'm not a history buff, but that being the case, the time, first of all, is the relevance as far as what happened then and the offense date. I don't see how him assisting, I believe he said some Americans, maybe 40 trips to the border, that being the Saudi Arabia border. I don't see how that's relevant to this matter. I do agree that he mentioned his injury. I will allow for him to testify about his arm injury, but not as to how it occurred and when it occurred, as far as dealing with the war and so forth. He can indicate, yes, I suffered an injury and I had an issue with my arm. It was dislocated. And if he said it bothers him to this day, if that's what the testimony will be, that's fine. But to indicate to this jury that he's allowed to testify about what he did or may not have done in Kuwait, because this is respectfully what he is telling or wants to tell this jury. I have no indication other than what he's telling, or would like to tell this jury. I have no indication of the veracity of that, but more importantly, as to the relevance of that. This case is about second-degree murder. This case is not about what he may or may not have done to assist Americans during the invasion of Kuwait and or Afghanistan. It's not about that. I don't see a relevant line that he can draw other than to ingratiate himself to the jury for sympathy, indicating that based on what he says, he's helped Americans in the past. That's admirable, but that is not admissible. Therefore, the objection is sustained. All right, and I'm assuming you're objecting to my ruling, so noted for the record. Anything further from the state?
No, Your Honor.
Mr. Newton?
No, Your Honor.
All right, we can bring the jury back.
Yes, Your Honor.
All right, thank you, Sheriff. Let the record reflect the jury is back in the courtroom. The objection respectfully is sustained. You may continue with your examination.
Mr. Zarka, without telling me how you sustained the injury, did you sustain an injury to one of your arms when you were in Iraq and in Kuwait?
Yes, sir. My right arm.
And what kind of injury did you receive?
Dislocation.
Okay. And does that injury still cause you problems to this day?
Yes, sir.
Why did you decide to come back to the United States from Kuwait?
Just for better future for the kids. Getting away from the war zone.
How many children do you have?
I have 3 beautiful children.
How old are they?
I have a son, he's 28 years old, and a daughter, she's 24 years old, and a daughter, she's 8 years old.
I take it the older children are grown up and they do not live with you?
Yes, sir.
Do you share custody of your 8-year-old daughter?
Yes, I do.
Now, When you decided to come back to the United States in 2000, did you come back to the United States in the year 2000?
Yes, sir. I came to back to America in the year 2000. I had a good job offer to work for a shipping company up in Baltimore, Maryland. And also at the same year, 2000, there was a very big international kind of examination that the Canadian government did do. And they actually granted me a landing, which is also kind of residency in Canada in the year 2000 to join the Canadian Chamber of Commerce over there due to my experiences.
And why did you decide not to go to or stay in Canada?
It's too cold.
So when did you moved into Raleigh at sometime in 2000, is that correct?
Yes, sir.
What kind of work did you do when you finally came to Raleigh or settled into Raleigh?
I had the choice to go back to the corporate world and or just to be on my own. And I studied the market, what is the best implementation for supply and demand, and something that I can deal with people. And I really found it in retail. I mean, everybody goes to the convenience store. Everybody always wants something. It's recession-free. And I mean, this danger, better the restaurants. And also, I like it. I like it dealing with all kind of people, races, you know. You get to know a lot of people.
Did you just open up a store, or how did that happen?
Yeah, after I made a decision that I want to be in retail, I got into the gas station business and convenience stores.
And did that start with one store?
I started with one to a point of time in downtown Raleigh. I had 4 of them.
Okay.
Yes, sir. But now, I guess I'm getting older. I can't handle the pressure anymore. Too many hours.
How long have you had your store at 207 South Wilmington Street?
I think this one, I did the license for it to open in 2007, 2008.
Okay. And so, $16, $17 years?
Yes, sir, this location, but I had other location before it on South Wilmington Street also.
Okay. How long had Mr. Philip Horwitz, who testified a little while ago, how long have you known him, and how long has he been a landlord for you?
Over 20 years, 21, 22 years.
So was he a landlord at one of the other locations before you opened to us?
Yes, sir.
All right. Tell me about the store. I know the jury has seen it, but when is it open? When does it close? What do you sell, and what do you personally do there?
Yes. I'm open 7 days a week. During the weekdays until 12 o'clock. On Thursday, Friday, Saturday, we stay open till 2 o'clock in the morning. But we open at 6 a.m. every day. And I merchandise everything as much as I can, have the variety of all kind of drinks, soft drinks, juices, sundries, candies, house supplies, tobacco products. Got the best beer selection in town, the best wine selection in town. I try to be picky.
What kind of hours did you personally work at the store?
Well, yes, sir. Until really started feeling really bad with that cancer, I am there every single day. This is my schedule. 5 o'clock I'm up, shower, do my morning prayers. 5:30 I'm in downtown. I lock the door behind me, get the fresh coffee ready, turn my radio, my favorite radio station on, and 6 o'clock sharp, the sign is open. 6 o'clock in the afternoon, 7 o'clock in the afternoon, I'm out of the shop.
Okay, do you have other people who work for you?
Yes, I do.
Now, in doing the business that you do and dealing with general customers, excuse me, do you have problems with people shoplifting or stealing items from you?
See, sir, I am a public business, and we get them all. I mean, I'll be behind the register. At the same line, there'll be an engineer, a DA, a homeless, a thief, a breacher. You know, downtown is a collective area. It has everybody. People come to visit downtown, people come to courts downtown, people come. I'm very close to the main bus station of the capital of the state of North Carolina. So that's a foot traffic. And everybody, a lot of people ride the bus regardless to what's their job description. And I serve all. I average almost 600 to 700 walk-ins a day, over 20,000 a month. So I get them all. You know, I'm a high traffic store.
How often, when you're working at the store, do you have to deal with people who are stealing from you?
I witnessed this town grow by the inch, one block at a time, one new business at a time. And you see, when I am the first one to be walking in the streets of downtown Raleigh,
Objection, non-responsive, sustained.
when I come early, I'm sorry.
Can you approach him with Mr. Zarka, please? Once the objection is sustained, ladies and gentlemen, we're going to stop now. We're going to return on Monday at 9:30. Ladies and gentlemen, please do not express an opinion. Do not form an opinion. Do not. You've been to the location now, but don't go now. Don't go back. You were allowed to go to the location through the jury view, but now that is ended. You're not allowed to go back to that location. Please.
Okay, so after this, what we're gonna do is now I'm gonna play the video of the incident of the confrontation for toxic, and then we're gonna talk about the rest of this testimony because this is the only thing we have available. So we're gonna do the video, talk about the rest of this testimony that I have the notes on, and then next I believe is the closings, but we'll double check and talk about what happened on this day of the trial. So I'm gonna to share this one instead and play the video.
Friends and family in the audience could be seen looking away and crying, along with the woman who shot the video of the incident on her phone. The court also seeing the bag that Garrity had with him in the store that day, along with the Gatorade he took from the store's cooler.
And I'm saying just give him the bag. Just give him the bag.
Earlier in the day, a now former employee who was involved in that altercation testified to seeing Garrity put the Gatorade in his bag and told him to give Zarka the drink back.
But it did.
Oh, that was just a bit of a snippet of it, of talking of like what happened. Right now, after that, they ended the day. When they came back on Monday morning, back then at 9:30, it was to carry on talking about the about his testified that he has prostate and bladder cancer, for which he's receiving chemotherapy for, and that he had treatment before he went to work that day for where he stabbed Garrity. And you're welcome, Toxic. Always anything for you. You are amazing, and I really hope you get better soon. Then they both rested. That was it. That basically was his testimony of Zarka testimony. Both the defense and the state rested. State did not have rebuttal. So when they finished questioning the lead detective, the defense, they had a little bit more of a case to put on before they actually arrested. They had at least 2 police officers from Raleigh that who frequently were at the convenience store almost daily and had interactions with Zarka. They both witnesses said they visited Taz Market hundreds of times over the years for calls regarding with shopliftings, to assault, to incidents that happened in store. I'm sorry, I'm just checking that I did not turn off the mic. Then there was Officer Timothy Rosa that called Zarka as an outstanding citizen who was respected by the community members and by cooperative law enforcement often when incidents happened in store. Then on cross, then on cross, both witnesses testified that others in the community did not like Taz. He was not very liked guy. Some calls to the store from customers reporting confrontations, that he confronted people quite often. And then there was a community member and customer called Richard Carter who visited with and met and chatted with Zarka multiple times, that he never saw Zarka being violent or threatening to anyone. And then there was basically the same things. So from other people, there was the landlord of the store that he never heard of Zarka being innocent and everything. So then there was never troublesome and everything. So they was like an outstanding guy that he never had problems. He was a pitch perfect person. And what did I just click? I clicked something that opened an ad on my computer. And then that was basically day 3 of the trial. Day 4 carried on with spend Zarka again. Going back to Zarka testimony because he was broken into too. Zarka on day 4 spent the morning on the stand as the last witness on the defense case. He Zarka testified on direct that he did not intend to injure or kill the victim, Mark. Sorry, just 1 second. Pausing the next video. Zark, and I can share actually this one, and it's here. Sorry. Zarka said that he drew the knife on Garrity in response to Garrity's aggressive reaction to Zarka's demand that he turn over the bag, or because Zarka wanted to expansion the bag, because he did not know what was inside what he actually had stolen. And then Zarka said that he drew the knife on Garrity. Sorry, I've already said that. Zarka said the customer speculated Garrity might be carrying a weapon. When he allegedly asked Garrity if he had a weapon, Zarka said Garrity told him he would stick his pistol up in his backside. Then Zarka narrated portions of the store civilian footage frame by frame that we watched, focusing on moments that he said showed Garrity pushing and grabbing Zarka's neck and hands as a knife wielding Zarka tried to wrestle with Garrity from him. On cross, the prosecutor pressed Zarka on why he didn't say anything to police about Garrity's pistol comment, who pulled a weapon home first, why Zarka didn't call the police, and why he didn't check on Garrity as he lay bleeding to death outside of the store. and then the state did not put on a rebuttal after Zarka finished his testimony. Then they were the typical and then defense lawyer said that he was acting under the authority of a state law that allows merchants and private citizens to detain people they suspect of a crime, but the JOA was denied. And then they proceed to the closings. So as normal, we're gonna watch first the prosecution's closings, and then we're gonna watch the defense closings back to back, and then we're gonna do a short verdict thing because there was actually some things that happened during this verdict watch, but we can talk about that when we get there, and we'll hear the closings of this case.
Not be who you want a murderer to be, but when it comes right down to it, he took Mark Garrity's life and he was not justified in doing it. So when you go into the law, there's ultimately going to be two real questions for you. Okay? As we told you when we first started this out, a lot of this we agree on. The two questions are going to be, one, when he killed Mark Garrity, was there malice? And the second one, which is the overarching question for all of this, is was he justified? Now, we spent a week in here talking about or showing you what was going on and talking around the issue. But the reality is, at the end of the day, you 12, get to decide the big question. Is what he did reasonable? And that word colors everything that you have to decide in this case. It colors the amount of the doubt that you're allowed to have. It colors every decision that he made. When they asked you and said that I was going to stand up here and ask you to kind of nitpick and parse through it, and that you have to look through his eyes and decide what did he think it was appropriate. Sure, that's one of the things that you have to do. But ultimately, it doesn't matter what he thought was reasonable. At the end of the day, his decision does not carry the entirety of the weight. What matters, he may very well have thought what he needed to do was stab Mark Garrity. But at the end of the day, if you did not think it was reasonable, then it was not reasonable. So, the defendant is charged with second-degree murder. And the judge is going to walk you through this, but second-degree murder is that the defendant wounded Mark Garrity intentionally and with malice and was a proximate cause of his death. Did he wound Mark Garrity? Uncontroverted, I think they agree, even though, and this is important later on, the defendant didn't even want to really admit how much he wounded Mark Garrity, right? I asked him several times on the stand, we could agree you stabbed him 3 times, right? He wouldn't agree to that. Well, I don't know. I only thought I stabbed him once, but if you can't agree on the objective facts here, then you can't trust anything that he's telling you. He stabbed him 3 times. 3. Is 3 reasonable? I'm going to submit to you that it's not. Did he do it intentionally? He didn't do it by accident. He told you he meant to stab him. You can check that off. So you can check 1 and 2. 3, was he the proximate cause? The doctor told you without those stab wounds, and this is important too, they agree that the stab wounds caused the death, but they wanted to argue about, well, maybe it was the drugs. It's kind of the underlying questioning that he was asking. If it's not for getting stabbed in the heart, 4 inches, 3.5 inches, and 2.5 inches, he's alive. So you can check that off too. So the big question is this one with the asterisk beside it, and that's malice. Now we're going to come back to this without justification. But if you take out the self-defense issue just on its face, did he wound somebody? Was it intentional? And was it the proximate cause? And was it done with malice? So, as I said, he stabbed him 3 times, and they want to negate these puncture wounds. I'm not saying that the puncture wounds are what caused the death, but they're going to be very important when we get talking about what's reasonable here and what his intent was, okay? I would submit to you, that's when you're going to start considering these things. It's on video that he wounded him. The autopsy told you about it. He even ultimately agrees. Now, did he intend to kill him? Doesn't have to. All he has to do is intentionally assault him, intentionally strike him and wound him, and if that leads to the death, then he's guilty of that prong. You must consider and infer the circumstances surrounding it. Here he told you he intended to stab him, so you can check that one off. Now, malice. Malice is hatred, ill will, spite. To be sure, it is malice. You're upset with somebody. You're angry with them when you do this action. That's what malice is. But it's also a condition of mind that prompts a person to take the life of another intentionally. Now remember, that definition of intentional for second-degree murder. Did he mean to assault him here? Or intentionally inflict serious bodily harm, which results in his death. He told you, I intended to stab him, and he died. So I would submit to you, malice is present here. So there's also a presumption of malice. If you use a deadly weapon intending to kill or cause that bodily harm, the law allows you to presume that malice exists. Okay? So here, you can presume it was done with malice because he used a knife. A knife is a deadly weapon. So as a matter of law, a deadly weapon was used, and you can now presume that the defendant had malice. Now that's all going to be important because if you have malice along with this intentional assault and he dies, it's second-degree murder, barring that self-defense issue. But what other evidence is there of malice? If you remember going back to the defendant's statement, his statement to the police, there are a few little nuggets in there that I think are important that shed light on his true state of mind at that time. He told you, I was in no mood to argue. He was upset. He had to deal with this guy who would not submit to him like 99% of everybody else does, and he got upset about that. He's mad. You don't stab somebody that you're happy with, okay? So these are the lens that you look through for malice. He was tired of people stealing. That's reasonable. But it's also a state of mind that gets into that lets you get into his state of mind. I'm fed up. I can take only so much. If you're nice to me, cool, but if you start mouthing back to me, it's on. And I would submit to you, that's what the defendant's thought process was. He did not like that Mark would not submit to him. He even told you that here. It's not about me, he said. What's in his head? Why wouldn't he just give it up? As if he has to do everything that the defendant wants him to do. He didn't. He was under no obligation when the defendant walked up to him to submit to his show of force. And I'm going to talk to you a lot about that later, but think about it this way. Where in the evidence is it that Mark even knew who the defendant was when he came up to him with that knife out? He walked up to him, what do you have in the bag? And he grabs him and points a knife at him. The defendant's told you how bad this area is. For all we know from the evidence, Mark thought that he was getting robbed here. Okay? So why does he have to submit to this person? He doesn't. And even if he knew he was the shopkeeper, he's under no obligation to comply with him. If you don't like what I'm doing, man, call the cops. I'm gone. He could have said that. But it's what upset the defendant. He just wanted him to submit to his show of authority. And I would submit to you, he uses that knife at the very onset of this, and he would like to indicate to you that he was only doing that out of self-protection. When he holds this knife up from Jump Street, has the bag, and goes like that several times throughout the course of this incident. This is not showing somebody that you have protection. I'm protected too. He threatens him with that knife. He's not allowed to assault him. But using a knife, as we've said, allows you to presume that there is malice.
I need to object to the word presume. I believe the law is they may infer that, but they are not required to do so.
Noted, overruled.
I would also submit to you to remember that it was 2 people versus 1. And that the defendant, while Mark is outside bleeding, never goes out there and cares for him. If there was not and I would submit to you, this is one of the biggest things that shows you the defendant's state of mind here. After all of this goes down, no matter what, don't you go outside and you know that there's a guy 5 feet from you bleeding out the way that you've seen him bleeding out? And you know he knows because you can hear the commotion outside. You see Nathan on the phone kind of looking out the door on the video. His state of mind, his heart doesn't tell him to go outside and give that man a towel to at least try to save his life. His state of mind is to start mopping so that he can go back to what is the most important thing to him in this situation, which is the almighty dollar, so that he can have the next customer come in and buy something. He doesn't shut down the store and take a 5-minute break to start breathing and go, oh my God, I was almost murdered. No. He stomps around the store when you see that video in an angry fashion, I would submit to you, not a scared fashion, and begins to mop up the floor while the victim is laying there mere feet from him, bleeding out and dying. That's ill will. That's spite. And daggone it, somebody would say that's hatred. So we can check off the proximate cause. And so if you find he mortally wounded the person intentionally with malice and was the proximate cause, it would be your duty to determine that he is guilty of second-degree murder, unless he was acting in self-defense. So I'm going to walk you through self-defense a little bit. There are 2 types of self-defense, and it's not really clear from the jury instructions as you'll get them that it's kind of referred to this way, but you'll kind of pick up with it. And they're referred to as perfect self-defense. So you won't see perfect or imperfect, but that's kind of how we lawyers talk about it so that you'll know the distinction. So perfect self-defense means that you have checked off every box. And if you check off every box of self-defense, then you are completely justified in taking the life. And if that happens, then you would walk out the door and never be heard from about this case again for you. He would never stand trial for it again. But he has to meet every element of self-defense. And there are 4 of them essentially. And we're going to talk about them. But if it is not perfect self-defense, it may still be imperfect self-defense. And so what that basically means is that the first 2 elements are satisfied of self-defense. And what we're going to talk about with that are the 2 things that Mr. Knudsen talked to you a little bit about, that the defendant reasonably believed that it was necessary to prevent death or great bodily harm. If so, that's the first one. But the second one is the one that I've told you is the most important here, I would submit, is that you agree with him that it was reasonable. If both of those things are there, but he has acted excessively or was the aggressor with non-murderous intent, meaning when he brought out the knife and used it, he didn't intend to kill the person, but he was still the aggressor, then you would not be completely not guilty. You just say, hey, this isn't second-degree murder, but it ain't not guilty. And so it's somewhere here in the middle, and the law is going to tell you that the answer for the middle is involuntary manslaughter. And we'll talk about what involuntary manslaughter, the elements of that are essentially later, but it's the same thing as second-degree murder. You just don't have the malice. Okay? So it's the intentional killing unlawfully of another individual, that results in their death without malice. Well, when you talk about self-defense, as I said, it appeared to the defendant that it was necessary for him to use deadly force to save himself from death or great bodily harm, and he has to have both of these. These circumstances were reasonable to a person of ordinary firmness. That's you. So you have to agree that what the defendant did was reasonable. Even if he agrees and you do not, then self-defense does not apply, and he is not able to claim it. Okay? And that would mean your inquiry stops. You can take self-defense and throw it out the window at that point if at the end of the day you don't think what he did was reasonable. And he would be guilty of second-degree murder if you believe there's malice, or involuntary manslaughter if you don't believe there's malice. Okay?
Homeowners, when your water or sewer line breaks, it's expensive.
Sorry, just bear a moment with me. I don't know what happened here. Because every time now that I click on that, it opens a new tab, and I don't know. Need to refresh this. Hang on. Hopefully it has marked where we were, because otherwise. Why is Core TV now giving ads? It never gave ads before, and now all of a sudden they started to give ads in the middle of the thing. Core TV is not my friend. I like Core TV, but sometimes I don't like Core TV. Oh my days! But the fact that the thing is that I was gonna.
Knife he intended to and broke out the knife and was the aggressor intending to commit the harm, intending to commit the murder, then guess what? He doesn't get self-defense either, even if 1 and 2 are checked. And it's back to that murder of second degree if you believe there's malice, or if you don't believe there's malice, manslaughter. Okay? But if you find that he was not the aggressor and he did not use excessive force, and both of those are met, so all 4, that's that perfect self-defense. Okay? And I know this is a lot of checking boxes and going through it, and it's not that much clearer when you start getting into the jury instructions. So that's why we try to break it down in the way that we do. But let's walk through it, because I'm going to tell you, I would submit to you that self-defense fails on prong 1 and 2. Okay, so you don't even have to get into this aggressor, non-aggressor situation, because I would submit to you it wasn't reasonable what he thought in his own mind or in your mind. So he told you he thought it was when he testified, and he said that, and the main reason that he thinks is because this quote that he's the only one that heard, and he's the only one that testified about it, about this gun. And we're going to talk about his credibility, but I want you to go back and everything that he testified to today and yesterday, you are the sole judges of the credibility of the witness. So you get to believe all, some, or none of what he says as true and apply that to the facts. I would submit to you that I want you to look at his testimony this way. Remember what he told the police, and remember what he told you. And ask yourself, Do those two things add up? Because when he told the police this, there was no mention about in his mind at that time that he walked around the corner that somebody else had put some idea that maybe he was in danger in his mind. That was brand new today. You heard it when I heard it, folks. Brand new. Wonder why that might be. Because he's had the videos and realizes, ooh, they don't add up to what I told the cops the first time. The other thing that I would submit to you is that sticking the gun up your ass part of this statement, that's different too. Did he ever tell you, and candidly, it got worse for him today, I would submit to you when you start looking at it. Because he says that when he walks around the counter the first day, when he talks to the police, that Mark volunteers this. If I open this bag, I'm going to stick a gun up your ass. Remember, he tried to be demure to the law enforcement. He said he was going to stick a gun up my. Today, that story's different. Today, he's the one that brought up the gun. When I grabbed him, I said, do you have anything in the bag, sir? And that's, oh, well, yeah, I've got a gun. And if you open this bag, I'll stick it up your ass. Well, if you really look at it, if you believe that today, that's not self-defense either, because at that point, the defendant's pointing a knife at him. So he would be the one that would have the ability to defend himself at that point. But at the end of the day, why would Mark say he had a gun if he didn't have a gun to a guy who has a knife out at him? He wouldn't. It's not believable. It's not believable that Mark's saying anything about this gun when you really sit and listen to the evidence that you heard in this courtroom on the tape and you watch what's going on. If this guy's over there saying, I had a gun, do you think Nathan Cowles, who said he never heard it, would have walked up and been right there beside him all while this is going on? Do you think that the guy in the red shirt would have walked up as they're get his drink out and stand there and watch him for a couple minutes? Is that reasonable to believe that Mark's saying anything about a gun here? Or is he saying what you hear him saying on the tape, which is, hey, man, I didn't steal anything. I'll pay for it. Okay, I'll pay for it, man. That's what's reasonable. There's nothing about this gun. There's nothing to corroborate this statement other than the defendant's own credibility here, which I would submit to you is shocking. This is a big point to me that I would point out to you. If you listen to that initial statement to the police, he says, I wasn't going to take any chances because he made a motion to his backside, and that's when I thought he was going to pull a gun out and harm me. Did you hear word one about that today? No. And it's not that you remember it differently than I do, go with your memory. But when you watch that video, he doesn't just say it. He gets up and acts it out for the police. Wonder why he didn't say anything about that today? Because it wasn't true. He was saying what he needed to say then because he thought it would work to get him out of it, which is what I would submit to you. It had worked every other time that he needed to say something. He just says what he wants to say to get out from under it because he's Taz and everybody likes old Uncle Taz. That's not how the law works, okay? So think it through. He never makes, even the defendant says he never makes a motion to go into that bag. There's never mention that he makes any effort to get this gun out of a bag because it didn't exist. And nobody thought it existed, even the defendant. The only evidence is him saying this. And what I would submit to you, another thing that is helpful in you deciding what was reasonable at that time is listen to the cell phone video and everybody who was at the scene, what they're saying in the background as it's going on. Do you hear one person out there saying, oh my God, he said he was going to stick a gun up his ass. I'd have stabbed him too. No, every person you hear is saying, they need to lock his ass up. He's racist. He's doing this. They need to focus on Taz. Taz is the one that stabbed him. Somebody even says, man, a store clerk can't do that. That's crazy. Pay attention to those people. They were there. They know what was reasonable. The red shirt guy, the guy with the glasses and the toddler. If somebody's screaming about a gun, you don't think they're scooping that kid up? Strangers would have been scooping that kid up to get him out of the store at that point. But no, that's not what happens. Is it reasonable to you consider all the facts and circumstances, the size, age, strengths of the defendant, the victim. I watched the video. It doesn't look like the defendant's getting jerked around so bad in that video. And if he's got cancer, I empathize with that. I sympathize with that. But by golly, when you watch that video, he is well in that fight. He ain't giving up on that bag, and he's the one that is body checking the victim, putting his butt in the way so that he can't get around it. And you all walked in that store and saw how tight that little area is right there, right? There was nowhere for him to go when he got him cornered in that area, when it's the defendant on one side, Nathan on the other, and the victim, Mark, in the middle of it. Where was Mark going to go? He had been held there for 2 minutes at least at knife point. I might try to get out of there too if I were him. But when you look at it, they're about the same size. They're about the same, I would submit to you, strength. Sure, the defendant's older than him. But that's just something to consider. And did the victim have a weapon? Objectively, the answer is no. Who had a weapon? The only person that had a weapon, that introduced a weapon into this event, is the defendant. And it's this knife. And that's not a little pocket, a little Boy Scout knife. That's a 4-inch blade, right? A 4-inch blade that the defendant walks up to the victim with, stands over him and lunges with multiple times. Gets him against that wall again. He says, I'm holding it back here. He's holding it back there so that the victim doesn't take the knife away from him in fear, I would submit to you. Okay? Think this thing through logically, with reason and common sense. So what is reasonable here?
There is a brief moment that it's not talking. I don't know what
Note the ice
happened.
cream. It's in the hand that he's saying,
they're watching a
wrenching
video.
his hand so harshly. Oh, there's another threat. Oh, there's another threat. What? Is that a stab wound? Still ice cream in that hand. That deadly briars that he has in his hand. Watch Nathan when he comes over. Watch who he really, when it really starts breaking down, I would submit to you, he's about to push the defendant away. Hey guys, stop. Chill out. Taz, cool it, man. Right there. Who's Nathan pushing? Watch him here. Oh, wait. He didn't chase him out the door, did he? Looks like he did there to me. Nathan again telling you that this is not reasonable. Hey guys, stop. And he's so scared of this weapon in the bag that he never looks in the bag. He didn't look in the bag until today. Is that reasonable? Does that make sense? Does it check out? Does it pass the smell test? I would submit to you it doesn't. Is it reasonable? Listen, and I'm sorry to make you watch this, but listen to the people that are in the background.
What the fuck, man? That shit sad as hell. This y'all, oh, that shit is sad. Taz was sad, you know. That shit is sad as hell. He's losing all. He's losing it. You just killed that man. You just killed that man. He's losing breath. That is a oh my gosh. Oh my God, that shit sad. Oh my mama, that shit. And they don't want that up like that shit is broken. They need to lock that nigga up. My mama. He's not breathing. Right. Oh my God. They have right. He's not talking to him, like, come at this time. I did not talk to him.
That's the reality of what it is right there, right? This Gatorade was met with this knife by that man. $3. $3. Reasonableness. Baseball bat and a pencil.
Homeowners, when your water or sewer line breaks, it's expensive and often not covered by basic homeowners insurance.
You could pay thousands.
Finding a good contractor can be tough.
Want this guy doing the job?
With a plan from HomeServe, call us. We'll send a contractor, and there's no big bill.
Sadly, I can't skip
But
the
don't
ad.
wait. Get a plan from HomeServe before a line breaks.
Go online now.
Plans from HomeServe start at just $4.99 a month. The debate continues.
A water line break will cost over $2,800 to fix. Get HomeServe to save money on repairs.
Want this guy doing the job? We'll send a qualified contractor quickly so you get HomeServe for less hassle.
Plans from HomeServe start at just $4.99 a month.
Pencil. Baseball bat. Is it reasonable? As I said, did Mark even know who the defendant was? He used a knife on an unarmed man. That's the uncontroverted evidence. We can quibble over the word immediately, but daggone, that knife was out the moment he walked around the corner, whether the blade was or not. He had it in his mind he was going to use that knife. And it is ludicrous for you to believe when you watch the video that one of those girls said anything to that man about Mark Garrity. When you watch what's going on, they're having a discussion about whatever they're trying to buy. And he walks by and shoos them out of the way. Get out of the way. I got business to handle. That's what's going on. He picks the fight, not the other way around. Mark isn't even able to get steps away from an ice cream cooler. He doesn't know whether he's going to pay for that stuff or not. And I'm not telling you that Mark didn't steal a Gatorade. What I'm telling you is this. The defendant did not know that he had stolen a Gatorade. And that factors into reasonableness. And how do you know that he didn't know? Because he sat right there and told you when he was watching that video, I didn't know if he was putting it back or getting another one. You are unable to tell. He had a hunch. He guessed, and sure, maybe he was right. But what if he wasn't? What if he wasn't right? What if Mark did have a cold Gatorade in his bag? What if Mark was somebody other than Mark? Was in a different store. Does he then get to go up and cut your Louis Vuitton bag because he thinks you put some Cheez-Its in it? No, that's not reasonable. Mark had both of his hands full. That man was not in danger of anything other than a freezer burn from a Breyer's ice cream. He never saw a weapon because there was not one. So was he the aggressor? Did he voluntarily enter or provoke the fight? Mark didn't go up to him with a weapon out.
He went up to Mark with the weapon out. That's the provocation. They want to split it down into this last 3 seconds. It's not about the last 3 seconds. You cannot separate this whole event. This is a totality of the circumstances. It starts from the moment he sees the theft and the thought process in his mind that he's tired of somebody stealing and he's going to go and get his property back at whatever cost. And when you're talking about reasonableness, and I'm going to talk about the aggressor again, but when you talk about the reasonableness, and we're going to talk about the reasonableness of the detention, how much does he want you to believe he gives food away? Then what was this to him? It wasn't about the taking. It was about the disrespect. He was pissed off that the guy did not submit to him as you're supposed to, like 99% of everybody else does. So use your reason and common sense. And we talked about the two kinds, the murderous intent or without murderous intent. And when you're determining this ability to was he the aggressor, that's where this faction about is he authorized to do this under the law comes into play. Is he able to detain a person in order to get his things back just because he is a storekeeper? And does that in and of itself mean, well, he had a right to do it, so he wasn't an aggressor? No. It's something you can consider, but what I'm going to tell you is that he did not have the right to do it the way he did it. And that's the important part here. Sure, a store clerk has the right to reasonably detain someone based on the facts and the circumstances of what the taking is. Okay? Had the defendant locked that door, had the defendant called 911, sure. Had the defendant even walked up to Mark as he has the bag and grabbed the handle of the bag and said, hey man, nah, we're going to wait here till the police come. He can do that. But that's not what he did here. He went from 0 to 100 in the blink of an eye. So he claims he had the right to start the altercation. I would submit to you he did not. He had the right to ascertain and try to figure out, hey, what's going on, but only in a reasonable manner. So did he have probable cause that a theft occurred? That's where I'm going back to. Did he? Or did he have a hunch? He sure didn't stop the other lady who he would have had probable cause to believe it. You see her clear as day putting the thing in the bag. He didn't care about her. He didn't stop her. He chose Mark for whatever reason. But was it reasonable in the manner considering the crimes involved? That's where we get back to a $3 Gatorade that the defendant wants you to believe he would happily have given the guy versus his grandpa's knife. It's not reasonable to approach the person with a knife out and push them, whether he wants to admit it or not. If you watch that, he ain't just being led around by Mark. Mark goes back on that table and he holds him down, I would submit, at least for a moment with some application of force, and wields that knife at him. At that exact moment, he's lost the privilege. It's no longer reasonable. He's assaulted him at that point. And you don't have the right to assault somebody in an effort to regain your property. Think it through. Does it make sense that you do? What if you're wrong? He's not even allowed under the law to walk up and do a pat-down search of him, much less cut the bag and demand to get inside the bag. If he's this concerned about it, wait for the cops to get there. You don't get to use deadly force to arrest a person committing a concealment unless he's escaping with the use of a deadly weapon or poses an imminent threat to others. Could a law enforcement officer have pulled his gun on that guy as he's walking out of the store with a bag and ice cream in his hand? No. He would not have been able. If he decided to run away from the cop with a bag of his clothing and an ice cream can, and that cop shot him, what do you think we would be doing here? People would be upset about that because it's not reasonable. Consider the volume of the items. Consider this, and this is why I ask these questions about these kids and everybody that's present. If the kids aren't there, maybe this is a different calculus, right? Maybe that's the thing that gets to you that says, you know, if it's an empty store and it's just Taz and that and Mark there, maybe you can get a little more aggressive with it. But you also need to consider the reasonableness in the totality of the circumstances. He's approaching a man, if you believe him, that he thinks has a gun, which in and of itself is unreasonable to approach a guy with a gun with a knife. But he's approaching a guy while there are small children and families right there in front of it. He's picking the fight and creating this risk for all those people, as opposed to just letting that Gatorade that he's not even sure that he took walk out the door and calling the police. He's 4 feet away from a phone before the victim even gets to the front of the store. He makes no effort to call the cops. And that's the reality of why he doesn't do it, is because in his mind, it ain't worth it to get the cops involved because I'm going to have to come down to the courthouse and deal with all the paperwork. I'm just going to help myself and get my stuff back. Well, when you read that law, where in this law does it tell you that the defendant has the right to self-help? It doesn't. It says I can stop you and figure out that you didn't commit a crime, or I can stop you and wait for the cops to get there. It doesn't say I get to go in your bag and take all my property back and stab you or do whatever I want to do to you. It's not reasonable. He never closes that door. There are less restrictive means by which he could have effected this detention, and he chose not to do them and went from 0 to 100 in the blink of an eye by introducing a deadly weapon. And again, he stopped him before he ever even tried to leave. So, the difference, as we said, if it's with murderous intent, if you're the aggressor with murderous intent, you don't get any self-defense out of that. In this case, if it was not reasonable. So, essentially saying, if one takes the life defending his own in a fight that he started with the intent to take a life or inflict serious bodily harm, there is no defense and he would be guilty of murder. That's the law. If he commenced the fight with no intent to take the life or to inflict the grievous bodily harm, then he is not acquitted of all responsibility, but the offense is reduced from murder to manslaughter. Perfect, imperfect. Is that an aggressor? Look at that. Who's the aggressive one in that? And the defendant, in his argument to you by Mr. Knudsen, he even, I don't know if he meant to say this or not, but I wrote it down. He said, he's not being aggressive for no reason. So we agree he's the aggressive one here? I would submit to you, he was the aggressive one. And it was not reasonable. Is that the aggressor? Is that the aggressor? Curiously, when he spoke to the police, when did he tell the police he took the knife out? Did he ever mention that knife being out at the jump street when he talked to the police? He waited until they got all the way down there before he said I took my knife out with the intent to cut the bag only. Where's he cutting the bag there? 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 That's the aggressor. Those puncture wounds show you who the aggressor was. They didn't kill him, but he ain't using that knife just to cut a strap. He's got the knife in his side. Look where those puncture wounds are. Watch that video. It's how he's moving him around. It's how he's controlling the situation with a knife. Flick it out. Is that the aggressor? Physical evidence of aggression. 4 puncture wounds. That's what the report said, but when they started asking, it kind of got worse for him, didn't it? There's this other one, I gave him the benefit of the doubt, but that's probably a puncture wound too. So 4 or 5 puncture wounds, where they are, no weapon found. You heard the audio of all the people who were there. He isn't honest with the police about the important parts about when he took the knife out and that he was only going to cut it. And then you move on. So if he's the aggressor, then he doesn't get self-defense here. The other way, though, is if he used excessive force, which is more force than is reasonably necessary. You get to decide that, and that's where we've talked about it during jury selection. One of you is probably going to get tired of us using your example, but the baseball bat versus a pencil, that's the proportionality. That's the proportionality. A fist versus a knife. It isn't proportional. It's not reasonable at best. The defendant had 2 cuts on himself that he caused himself and no bruises. The victim had 3 stab wounds, 4-inch, 3.5, 2.5, and 4.5 or 4 to 5 puncture wounds. Who's the aggressor here? If this beating was so bad that he's talking about that you watch, and I would submit to you, he gets punched 1 time, and it's after he's had a knife on him for several minutes, and he's trying to leave. Is this excessive force?
That shit you see downtown, that fuck nigga Taz. I'm dead as hell. Yeah, he touched me like that. We got a problem. I'm fucking his old ass.
She sure thought he was the aggressor.
He gonna set her away. He got that money back. Wow. That shit's sad. Oh my mama, that shit's sad. Oh, that's right there on the way.
Stealing.
This shit's sad. My mama, that shit's sad. That shit's sad. That shit's sad. Oh my mama, that shit's sad. That shit's sad as hell.
Homeowners, when your water or sewer line breaks, it's expensive and often not covered by basic homeowners insurance.
You could pay thousands.
Finding a good contractor can be tough.
Want this guy doing the job?
With a plan from HomeServe, call us. We'll send a contractor, and there's no big bill.
Easy.
But don't wait. Get a plan from HomeServe before a line breaks.
Go online now.
Plans from HomeServe start at just $4.99 a month. The debate continues.
A water line break will cost over $2,800 to fix. Get HomeServe to save money on repairs.
Want this guy doing the job? We'll send a qualified contractor quickly so you get HomeServe for less hassle.
Plans from HomeServe start at just $4.99 a month.
When you're
doing this excessive force calculation, remember, the calculation is a knife versus fists. It's not a knife versus guns here. Okay? That's the defendant at the police station right after this event. Where are any injuries to his head? In fact, he's kind of smiling. That's the victim right after this event. As Bradley got up here and cried about what his last words to him were right about that moment. Am I going to die? Compare the injuries between the two of them. You tell me, is one excessive? Because, quite frankly, there are no injuries here. And these injuries are ones he caused himself. He told the police, I can take a punch, I can punch back. Well, if you can do it, that's what he should have done. He gets in a fist fight, everybody walks out of this thing alive. But as soon as he introduces a knife to it, not everybody gets to go home. He's tough. He tells you about his upbringing, what it was like to grow up where he was, the things he's seen. He's been in that downtown Raleigh for 25 years plus. And I'm not saying that he brought this on himself by opening a store, if that's what Mr. Knudsen believes that I was trying to convince you of. That's not what I'm saying at all. What I'm saying is it's a factor for you to consider in reasonableness. He knew where he was. He's told you over the years, this is not the best area I deal with. He did all the math for you, the number of shoplifting. Do you really believe that this is the first time he's walked over to somebody with a knife in his hand as he wants you to? That defies logic. It defies common sense. This is the one time in 20 years he did it. If he's done it here, I would argue to you he's done it before. So if you believe the defendant, that he believed it was reasonable, and I want to be clear about this reasonableness thing, what he had to believe. He had to believe it was reasonable to prevent death or great bodily harm. Not just any harm, not a busted eye, not a little cut. It had to be great bodily harm that he was defending himself against. Was Mark going to commit great bodily harm against him with his fists, as you saw it right there on a guy with a knife? Not reasonable. Fails on prong one. Fails on prong two, because I would submit to you it should not be reasonable to you. You would not have put yourself in the situation as the aggressor to do these things. And you would not have exceeded your scope as a store clerk in an effort to do that. And that it was not excessive force. If you believe that it was all of those things, he gets a pass. But again, if he fails on the first one, or he fails on the second one, or he fails on the third one, or he fails on the fourth one, he loses on the idea of self-defense. He has to have all of them. And I would submit to you, we have proven to you that he has none of them. If one of them is missing, it's murder. So, what I would submit to you, ladies and gentlemen, is this. When you're looking at this idea of the first prong, what was reasonable in the defendant's head, I will point you to a quote, and it's a quote from Alexander Hamilton. I don't think it's in the play. It says, "No man ought certainly to be the judge in his own cause, or in any case in respect to which he has the least interest or bias." He had interest and bias here. He tried to judge this circumstance. He judged his own actions. He doesn't get to be the final arbiter here because he has this interest, because he has this bias. As Detective or as Officer Rosa said, he is sometimes overly protective of his items because he has this interest in them that they're his and it's not some corporation. It's not reasonable. He should not get to be the arbiter of that. You get to be the arbiter of that. I would also remind you that, and I'd point out those store, those character witnesses, where was one of these people that the defendant, that loves the defendant so much that shops in that store? Who loved him? Cops and business owners. You didn't hear a single witness from him, and he traipsed in a lot of them. He had no burden of proof, right? But he traipsed in a lot of witnesses for you to tell you what a great guy he was. And maybe in their mind, he is a great guy. I'm not saying he's not a good person. What I'm saying is he did a bad thing. And good people can do bad things. And it is still against the law. You don't get a pass just because you've done well up until a certain period of time. You still have to be held responsible for the decisions that you make. And the decision that the defendant made that day was to exceed the scope of his authority. And he exceeded it by stabbing the victim 3 times with this knife. Not once, not twice, but 3 times. And they want to point out, well, there's no indication until he was punched is when he first got stabbed. The defendant even conceded, I think I stabbed him before you see the blood on his shirt when he was on the stand. You watch that video, there had to be a 3rd time that he got stabbed because it isn't in that secondary motion. It isn't in the secondary part. You maybe see 2 there. It's excessive force. It's not reasonable. And the defendant was the aggressor here. As such, I'm asking you all to find that no self-defense applies. He's not earned the right to self-defense based on these facts. In fact, I have proven to you that it was not self-defense, and he would therefore be guilty of 2nd-degree murder. At best for the defendant, I would argue to you that he was an aggressor without murderous intent and that he used excessive force. So if you find that he was reasonable and you think he was reasonable, I would submit to you he still fails on the second 2, and at best, it's involuntary manslaughter. But I would submit to you this is the unlawful killing of a human being with malice to approximately cause their death, and that it was not justified based on the reasonableness here, the proportionality of it all. $3 for a Gatorade for his life. And I will leave you with this. The defendant, in their opening statement, which is not evidence, but what the defendant said to you in opening statement was some version of a quote that was, I think all of us would give anything that we could to not be here today. There was one person that had the opportunity to do that, and all it would have cost him was this Gatorade, to let it walk. But his ego, he blamed Mark's ego. He said some people's heads, they're too strong. The only person with a strong head here is the defendant, who couldn't stand the disrespect and the fact that Mark decided he was not going to let him search through his bag that contained all of his personal effects, his clothing, his toiletries. And he wasn't going to leave it behind. And the defendant was upset about that. And the defendant took his life by stabbing him 3 times over a Gatorade. I would ask that you find the defendant guilty of 2nd-degree murder. Thank you, and thank you for your time.
Wow, that was such a great opening. Sorry. Closing by the prosecution. And the thing is, right, he was I agree with what you guys are saying on in the chat. Don't get me wrong. I'm trying just to do 2 things at the same time. He did not he probably, yes, he was a great person. He had a good community. He did whatever he did in the community and everything, but he did not have to do this. I don't think he was justified. And a very funny night, but yeah, sound, I haven't touched the button. The thing is, I got a new microphone. I was able to get a new microphone. I'm still getting used to it, and by accident I pressed the button that is underneath the microphone, and that mutes. But it's a good thing now. I know that it works. But yeah, I think this prosecutor was very good. He did drag out slightly a little bit, but it was good. But now, anyway, now we're gonna watch the defense closings, and I don't think this one has. It has to think about what, 3 ads. The thing is, this is not like I have YouTube Premium, so this is not from YouTube. Sadly, there was not available this video on YouTube. So this is directly from the Court TV's website. That's why it has a bit of ads in the middle. Hopefully we'll be fine with that anyway. We'll be okay. Hopefully next case we covering, he doesn't ask this. So yeah.
Good afternoon. First, I would like to commend you on being willing to come in and do the difficult task that's been assigned to you. It is asking a lot for a group of people to come in and make weighty decisions that affect people's lives. As you can see, there's been a lot of evidence relating to a very short period of time. I had even considered in the course of my argument pulling up and playing the videos again or showing still frames or passed them out. But given the fact that you just saw them this morning, and I know that you were taking very careful attention to that, I'm not going to go through that exercise again. I think that what has happened is both through the state's evidence and the defendant's evidence, we've attempted to give you the clearest possible view on what happened. I'm old. I've been doing this a long time. I have stood up in front of countless juries in situations where I have said to them, wouldn't it be wonderful if we had a video of what happened? Because in 99.99 something percent of the time, we don't. We're just trying to construct from scraps of what some people may have saw or heard, and of course, when we deal with human beings and what they see and hear, the human frailties come in there, and there's questions about how accurate things really are. And I say that because in this particular case, some people have said things about what happened and everything, but you've had the opportunity to see it yourself. And sometimes, as in this case, there may have been some misalignment between what people described and what you were able to see with your own eyes. But just because you had the opportunity to see it with your own eyes doesn't mean that in a legal sense, it necessarily explains itself completely. And so I'm not going to argue at you as that term is ordinarily stood. My job is, I see it as trying to be a guide to help you sort through the evidence and the facts that you've seen and apply that to the law in this particular case to help you get to where you're going to go. Now, the one thing that is very important in this particular case is that you're really instructed that when you do so, you have to put yourself in Taz's place. You have to try as best you can as a human being to see things through his eyes and to be thinking about his thought processes when things were happening that you can see yourself. Because in the final analysis, what you're going to be asked to do is to determine whether what Taz did under these complicated circumstances and this trauma and the violence and all the rest of it was reasonable under all the circumstances. And a test of reasonableness is one that you apply to yourself. And it basically, most people believe themselves to be reasonable people. And so if you see something and you say, that seems reasonable to me, or in judging someone's actions, if you look at it and you say to yourself, if that were me, would it be reasonable for me to do that? Now, the way that we do the order of things is that if the defendant puts on evidence, then the state gets the last argument. We go first and they get the last argument. And if any of you have ever had an argument with somebody, maybe a significant other or somebody else, that last argument is really important. You know, sometimes who speaks last, I mean, that may be it. So so this is my only opportunity to talk to you. So I would ask you to do one thing. Mr. Latour is a great trial lawyer. He represents the people of the state of North Carolina very well. But when he gets to his turn and starts to argue things to you, there may be this part in your mind that I would ask you to do, well, what would Mr. Newton say about that? Or what is the response to the argument? Because I won't be able to give it to you. And the judge will tell you, you have to keep an open mind on all of the matters here unless and until after everything is done, everything has been said, the judge has instructed you on what the law is, and then you can go back into the room. I think sometimes lawyers say a lot more than they have to, simply because we're lawyers and we're given the opportunity, we'll do it. I would submit to you that as you sit there now and you've seen all the evidence, I think you're beginning to get a pretty good grasp of this situation.
We'll have more of the defense team's closing argument in the murder trial for Taz Zarka right after the break. Stay tuned. We'll be right back.
Waterline broke. Replacing could cost thousands. Not covered by homeowners insurance.
Honey, wake up. Here's Tom Rusin, CEO of HomeServe.
A plan from HomeServe pays for the covered repair costs for water lines, and we send a qualified contractor. The American dream of owning a home doesn't need to be a nightmare.
Sleep well with HomeServe. Plans from HomeServe start at just $4.99 a month. The debate continues.
A waterline break will cost over $2,800 to fix. Get HomeServe to save money on repairs.
Want this guy doing the job? We'll send a qualified contractor quickly so you get HomeServe for less hassle.
Plans from HomeServe start at just $4.99 a month.
Franklin Ty Tucker has negotiated a plea deal and is now a free man. He reached out for a possible mistrial, Garrity rather, and
a good citizen in Raleigh, North Carolina, how he came to be a valuable contributor to society and how he has interacted with people on the street, in his stores, other business people, and in this case, with the police. How he has lived his life and how he has operated his business and everything and how he's cooperated with the police. Told you, among other things, that he has people stealing from him all the time. In this particular case, in addition to Mr. Garrity stealing from him, if you just looked at the video, one of the other people was sticking something in their purse, orange juice or something from the drink. The woman who was taking the video for reality TV helped herself to Taz's merchandise because other people were busy with a traumatic struggle and nobody was looking. One of the videos shows the man who's standing there at the beer counter, beer cooler with a beer, watching the thing goes down. He just walks out with it. It's an opportunity. If I pay for anything, I'll just take it. One of the issues that is going to be at play here is and Mr. Latour was asking questions about it. Why didn't you lock the door? Why didn't you call the cops? I'll submit to you that the answer was that Taz locked the door and called the cops every time somebody tried to steal something from him. He wouldn't get a thing done, and neither would the police. And they'd be being called in there when they could be better serving the public by helping people who were being robbed or beaten up or whatever. But in this particular case, we know that what Taz did was he did what he did in 99% of the cases, which was to go and detain them. Find out, in fact, whether they're stealing. If they were stealing, deal with it in probably a compassionate and humane way if that's called for. But only in the event that they were resistant, violent, or caused a problem, was it ever necessary to get the cops involved in the first place. Now, I asked some questions for him about, what he understood his legal authority to do that to be. We didn't find out then, but you're going to find out in the course of this when Judge Gregory tells you that a merchant or a private citizen has the authority to stop and detain somebody that they have probable cause to believe is engaged in a crime involving the theft of property. I mean, that's your life experience. I mean, everybody knows if you go into Target or any of these places or whatever and you steal something, the store security's gonna come up and say, you need to stop right there. You need to come with me. I need to get in your bag or whatever. It's nothing unique to this situation whatsoever. And to keep people from, and to keep the people that are stopped from whining and complaining and suing people because they've been unlawfully detained or whatever, the law gives the individual that privilege to do that. Okay, and the way that will be important in this particular case is that there is a concept in the law as applies to self-defense about being the aggressor. Okay? And in common terms and understanding, if you pick a fight and start a fight, you can't complain and then use self-defense if the person fights back or whatever. In this particular case, Tad didn't go to pick a fight. He was not being aggressive toward this man for no reason. He was simply doing what the law allows him to do, to go and detain somebody and to seek to protect his merchandise and be able to continue on as a going concern. The law basically is if somebody does that, detain somebody in the course of it, and they're reasonable in what they do under the totality of the circumstances, that's a defense to commission of crime. So anyway, I told you at the beginning, we would talk about the before, the during, and the after. We know about Taz's background and what he did that led up to this, what he was doing. Mark Garrity, we really don't know that much about. We didn't hear from anybody to tell us about what kind of a person he was. Nobody came in to offer evidence about his character and background, reputation. The only things that we do know about him are, one, that he didn't have any identification on him in his person or in his bag, so they didn't know who he was. Two, the way they found out who he was by running his fingerprints. Three, we know that he was an addicted user of drugs. Four, we know that he was stealing from Mr. Taz. I mean, that issue has been conceded the entire time, and so it's a little surprising to hear the state cross-examine Taz about, well, isn't it possible that he could have had that Gatorade in there and that it wasn't your Gatorade? You don't know for sure that was your Gatorade at all. Well, except for when the cops got there and they opened up the bag and took the Gatorade and physically held it, it was cold. And my guess is, number one, he wouldn't have been wandering around the streets with a bottle of Gatorade that was still cold. And if it was his Gatorade, what in the world was he doing over at the Gatorade cooler looking at stuff? I mean, there's never been any question at all about the fact that that's what he was doing. He was going to steal that Gatorade. Mr. Latour said, well, you know, I mean, how you know, maybe he didn't get the opportunity to get up there and pay for it. The state put in all this belongings. They got the clothes that he had and everything, and his personal effects at the hospital. Had no identification. He also had no ability to pay. They introduced the evidence of his personal effects that were found in the bag and everything. Nothing in the bag to indicate that he had the ability to pay. So, you know, that's unfortunate. Okay. But what it also tells you that from the minute that he walked into the store and went to get that, he never had any intention whatsoever of paying. So what do we know about Mark Garrity? We know that he apparently has lots of friends and family who filled up this courthouse. And I would suggest we know that he was a troubled young man. He was a human being. Taz, when he found out that Mark Garrity had died, you know, his response was, you know, sadness, because he was a human being. And the fact that this didn't need to happen.
More closing arguments from the defense on the other side of a short break. Stay with us.
Waterline broke. Replacing could cost thousands. Not covered by homeowners insurance.
Honey, wake up. Here's Tom Rusin, CEO of HomeServe.
A plan from HomeServe pays for the covered repair cost for water lines, and we send a qualified contractor. The American dream of owning a home doesn't need to be a nightmare. Sleep well with HomeServe.
Plans from HomeServe start at just $4.99 a month. The debate continues.
A waterline break will cost over $2,800 to fix. Get HomeServe to save money on repairs.
Want this guy doing the job? We'll send a qualified contractor quickly so you get HomeServe for less hassle.
Plans from HomeServe start at just $4.99 a month.
So welcome back to Court TV Live. I'm Ashley Wilcott. But you have to put yourself.
He's going closing.
Hey, the state.
Him in vigor that a lot of because
victim was
not get taken down to the floor. And as he put it, he was just trying to get him off. Just trying to get him off of me. The use of a knife, which actually causes serious bodily injury or death to somebody, is the use of deadly force if it turns out that way. Most of the time it doesn't, but sometimes it certainly can. But it's not like Taz pulled out a gun and shot him 5 times. Okay? I would submit to you under the evidence there was zero intent in Mr. Taz's mind to cause death or even serious bodily injury. It happened. But I would submit to you that when they came together like that, it was as much Taz reaching out as it was Mark Garrity coming on him. Taz is charged with second-degree murder. Person who's charged with second-degree murder is charged because the state alleges that they unlawfully and willfully killed another human being with malice. And for those of you who think you need to write down everything I'm saying about the law, I'm going to tell you this. This is a set of detailed instructions. It's a roadmap. It's going to lay out pretty much the things I'm saying about what the crime of second-degree murder is. There's also a lesser included offense of voluntary manslaughter. That's going to lay all that out for you too. So I'd rather you listen to me than write. A person who acts in self-defense is not guilty of any crime. A person who uses force that is deadly force is acting in self-defense as if at that time they had honestly had a personal belief that acting in that way was necessary to save themselves from great bodily harm or potentially death.
All right, we need to take a break. When we come back, of course, we're going to hear more from the defense attorney. He has 90 minutes to make his closing argument. We'll take you back in on the other side.
Water line broke. Replacing could cost thousands. Not covered by homeowners insurance.
Honey, wake up. Here's Tom Rusin, CEO of HomeServe.
A plan from HomeServe pays for the covered repair cost for water lines, and we send a qualified contractor. The American dream of owning a home doesn't need to be a nightmare. Sleep well with HomeServe.
Plans from HomeServe start at just $4.99 a month. The debate continues.
A waterline break will cost over $2,800 to fix. Get HomeServe to save money on repairs.
Want this guy doing the job? We'll send a qualified contractor quickly so you get HomeServe for less hassle.
Plans from HomeServe start at just $4.99 a month.
Courtroom now, the defense is still delivering its closing argument.
To do that, putting your hand on somebody's bag and trying to get it away from them is eminently reasonable force. It is also reasonable under the circumstances to, as Tad did, to show them that they had a means to defend themselves, so maybe the person would settle down, calm down, and behave. Unfortunately, that didn't work in this case. But he is not, by virtue of his interacting in that way. And by the way, he didn't put his hands on Mark Garrity. He didn't go up and grab Mark Garrity. He grabbed the bag. And the only reason that his having his hand on that bag continued any physical interaction between the two of them is because Mark Garrity kept trying to pull it away. And not only did he just try to pull it away, you saw from the videos that he was literally and physically taking his hand and twisting Taz's arm to try to break his grip from the back. Now, we're all sitting in a very nice, well-lit, warm courtroom. It's peaceful and quiet in here. We're not threatened and in danger. And yet, I would submit to you that soon you're going to be asked to pick through every little thing that Taz did in this circumstance and do what I would call Monday morning quarterback. Okay? I'll go back to what I said to you. When you analyze this evidence and when you're trying to determine the effect and reasonableness of what occurred, you're going to have to do that through Taz's eyes. I would submit to you that if you do that, and if you say, I've seen it in very, very detail, and if it was me, if I was confronted with these circumstances, if I was his age, if I was this, then I would think it reasonable to do what he did. That is, in essence, the function that you're going to have to do. Now, also bearing in mind how quick and how traumatic this whole situation was. Now, you're going to be told by the judge that your verdict has to be unanimous. You're going to go back into the room and you're going to talk about it, and it's going to be, what do you think? What do you think? What do you think? And it's likely to be, let me put it this way. It is not unusual for there to be differences of opinion between the jurors. And you all have a duty to consider the opinions and recollections of your fellow jurors. But when you make up your mind about this and you are have arrived at a conscientiously held opinion about it and what your verdict should be, that's yours. You can keep it. Regardless of what anybody else thinks, that's your opinion, your verdict, and you're entitled to it. I would also caution against the notion of trying to how you go about arriving at your verdict is your business. But the one thing I would suggest to you that would not be in keeping with your oath is to agree to something that you don't believe in simply to go along with the other people to get something done. That was something that I asked about in jury selection, and you all said that you wouldn't do that. The members of the jury, the last thing I'm going to say about this is Taz does not have to prove to you that he acted in self-defense. The state has to prove to you beyond a reasonable doubt and entirely convince you and fully satisfy you that he did not act in self-defense. And I would submit to you that a reasonable doubt will be explained to you as a doubt based on reason and common sense arising out of the evidence or the lack or the insufficiency of the evidence, as the case may be. It's an honest, moral misgiving about it. It is doubt which is based on your life experiences. And I would submit to you, it also exists in that frame of mind where you find yourself saying, geez, I don't know for sure what to think. Because if you don't know for sure what to think, and if you don't know for sure that this man unlawfully and willfully and with malice killed Mark Garrity, you would have a duty to say that he's not guilty. If you have not been fully satisfied and entirely convinced beyond a reasonable doubt that he did not act in self-defense, you must say that he is not guilty. If you are not fully convinced and entirely satisfied that he did not reasonably act to detain Mark Garrity, you must say that he is not guilty. And I would submit to you, ladies and gentlemen of the jury, when you get back and you consider all of that in light of what you've seen in this courtroom, that you will find yourself believing that the verdict in this case should be that Taz is not guilty. Thank you very much.
All right, so that was the closings for the defense. So now, while we are doing something, I can choose this. We see. Hopefully, this will work, and I'm not muted again. All right, so it's official. We have a verdict in the case. After probably a day and a half of deliberations, the jury did find they got to a decision. They had some questions though. They asked to rewatch the surveillance video of the altercation, and they also asked whether Taz had the right or not to detain and search the victim in the store. So they deliberated for a full day and a half, and then on day 6 they reached a verdict. So now we're gonna watch the verdict. It's a very brief video. It's about 43 seconds. So we're gonna watch the verdict and then see what happens. It's a mystery, I guess.
You'll stand, and Madam Clerk, if you will announce the verdict.
Ladies and gentlemen of the jury, your foreperson has returned a verdict in file number 23 CR 285-987-910. The state of North Carolina versus Taiseer Zarka. We, the jury, by unanimous verdict, find the defendant Taiseer Zarka to be guilty of voluntary manslaughter. This the 18th day of December 2024, signed by your foreperson. Is this your verdict? So say you all.
Yes. All right. And Mr. Zark, you may have a seat with your attorney.
Welcome back to Court TV Live. I'm Mike.
All right, so guilty on the lesser included, so involuntary manslaughter. I hope is that how you say. So that was a good call. Now, straight away, literally almost immediately, I think they had a break though, because when we are back in court, we have the penalty phase. So we get to see as well the sentence of Zarka. So now we get to the side. So the jury still had to go back in and deliberate some more. They had to decide what kind of penalty you would get. But as the title says, there was no decision in that. So it was up to the judge to decide. It's like kind of like, Carly Gregg, when they had to decide on the sentence, they had to deliberate. They did had on that trial, they did reach an agreement, but on this one they didn't. So we'll go watch now that part, because I think that's what happens, that they decide that they could not reach a unanimous decision on this. And then we get to see as well some impact statements from the court. Yeah, so we're gonna watch this one, and then we're gonna watch, I think it's the mom of the victim. She speaks as in impact statements, and then we get to watch the sentence.
I'm going to ask you and your colleagues as a whole, by a show of hands, do all the members of the jury believe that, in fact, if the court were to allow them to do more work, that in fact there would not be any further movement on the numbers that your colleague has informed the court of, that number being 8-4. For those of you that agree with your colleague that further deliberations would not be helpful, please raise your hand. Let the record reflect, raise them up high, please. Thank you. Let the record reflect that all jurors have raised their hands, indicating that they agree with their colleague that further deliberations would not be helpful, and therefore the numbers would not change. Is that correct? Once again, by a show of hands. Let the record reflect all jurors have raised their hands. All right. As a function of that, the court will make a finding that the jury, for the portion, this is a bifurcated trial, for the portion dealing with whether or not an aggravating factor in fact existed, the jury, based on state's or court's exhibit number 3, deliberated for 90 minutes. The numerical split was 8-4. The court has inquired of the jury foreperson and of the jury as a whole. All agree that further deliberations would not prove to be beneficial, nor would there be movement. Therefore, it appearing to the court that there is no reasonable probability of the jury's agreement on a verdict as to whether or not an aggravating factor, that being aggravating factor number 13A, exists, the court will declare a mistrial on this portion of this matter, recognizing that the jury previously, for the substantive portion, did find the defendant guilty of voluntary manslaughter. Mr. DA, it would be my intention to send the jury into the jury room for a few moments, discuss with the lawyers on the record something, and then bring the jury back and then release them. Any objection?
No, Your Honor.
Any objection?
No, Your Honor.
All right, Mr. Malik, and then I will bring you back out. When I bring
So, okay, so it was a mistrial on aggravating factor penalty phase of the trial. Now they go back and they talk it over. They do whatever they need to do to discharge the juror, but then they come back and they start with the sentencing. So the first video that we're gonna watch is the Zarka talks. He gives his statement to the court, and then, like I said, we're gonna listen to the victims' moms, and then the sentencing, all in order, and probably back to back. And then at the end, we can talk about a little bit more, or we can just talk about in chat about it. I think the aggravative factor was if it was intentional or not on his part. If so, the jury could not come to an agreement on that.
This is a lifetime experience. Never, and I hope never will happen to me or to anybody else. I come from a good family, and the way I see now, met the family, I'm sure he comes from a good family. But sometimes things happen where people go off the road. The deceased, I look at his pictures when he was much younger, good-looking kid, could be an engineer, could be a doctor. But he went off the road for a while. I'm a hard-working man, busy. No disrespect, I wish he never came in. I wish I was never put under the feeling that he's really carrying. I wish he just listened to me, or put the bag, or open the bag. It just happened. That's our destination. I have family who will be mourning and crying. I know his family are mourning and crying. It's Christmas time. Hail by your God or my God. I come from Palestine, where every prophet was born. The Holy Land. I know what love and respect is. I know what religions are. I know all about Bible and Torah and Quran. But a human is a human. A human is lost. He's the age of my son. The most important thing, Your Honor, that it's not a matter of holding grudges. I don't hold the grudges, and they shouldn't. Because they're going to live in pain for the rest of their life if they keep holding grudges. Things happen. I'm not going to sit here and try to look good by making them look bad or their son look bad. That's not how a real man does. I wish we met in better circumstances. I have a daughter, 8-year-old, now she's going to go home, and I raised her since she was 2.5. She's going to go home, and I'm not there. I work so hard, not because of the dollar or over a Gatorade, like some people want to show me. No. I work so hard because I have responsibility, because I love my work. I love my community. As I told in my testimony, when certain jobs, when you're behind your counter, you're the barber shop in the corner, you're the man at the store at the corner, it becomes big family. And I have thousands, a huge family, from all races, all colors, all religions. I am the man from Palestine, but I feed Christians every single day. And my landlord, the old man who came here, he's a Jew. Yes, sir. I really wish peace to his family, to their hearts, because their son is with God now. And all I believe that their son needs prayers, regardless. It's not about what happened. I'm not going to hold the grudges against them. My family, I have a father, he's 87 years old, and mom, she's 83. They're sad. I support them. But life goes on. So if I keep getting mad and my family gets mad and my friends get mad and friends get mad, that's not as humans what God wants from each one of us, regardless of your religion. Things happen, mistakes happen from both parties. My husband and wife love each other to death, still get separated because of misunderstanding. Things happen. And I'm sorry it happened from the bottom of my heart. And I wish his family peace as much as I wish my family peace, because they're going to be in pain. Especially my 8-year-old baby girl. And I am not a monster. I was never been, and I will never be. It's an aggression I was put under. At that moment, I felt it was a violence that I had to defend myself. And I tried. I raised my hand. I tried to back away. But it didn't work. God bless him. He kept coming back at me. I made mistakes. He made mistakes. What do we end up with? Everybody is sad. Everybody is mad. Everybody is in pain. So, my love and respect to his family. I really wish it from the bottom of my heart, if they can, I'm sure they're sad. I wish them the best of the holidays. And I give him a word of honor. If that kid came to me and said, Uncle Taz, everybody calls me Uncle Taz. Uncle Taz, I'm hungry. I give him a word of honor. I'll definitely, gladly help him out. And I do this on a daily basis for almost 4 decades. Because where I come from, God will bless you back. The karma comes back. Thank you, Honor.
I'm going to indulge. I'm going to assume Amy is spelled A-M-Y.
A-M-Y-G-A-R-R-I-T-Y. And I'm Mark's mother.
And take your time, man.
Mark was born on December 6th, 1995. And he would have turned 29 years old this year. Mark had blue eyes and sandy blonde hair. And he had a bright red birthmark in the middle of his forehead. Bright red. And the doctor told me it was called an angel kiss. And from that moment, I knew Mark was an angel sent from God. And all I wanted to do was protect him. My purpose in life was to be a mom, and I was meant to be Mark's mom. Mark was born in New Jersey and lived there until he was 12 years old when we moved to Wake Forest, North Carolina. In a safe family community, raising our son with God, family, and Southern values. I was Mark's biggest cheerleader. Mark was well-liked, polite, and respectful. Mark didn't know a stranger. He cared a lot about people who struggled, especially with addiction. Mark knew how to help people, and if he didn't, he called me and asked me to help so-and-so out because they had no family, no transportation, or no money. Mark was always calling his friends and family when they least expected it, just to check in on them. Mark was an old soul. He didn't text, he called people, and he loved to listen to stories from his grandparents. He loved history. He loved watching documentaries. Mark connected with many in recovery, especially his mentors that had been in recovery for many, many years, and how they maintained their sobriety. Mark admired them. I think Mark would have worked in recovery one day had he had the chance. He had a lot of respect and admiration for the programs that actually did help Mark. My son Mark struggled with substance use disorder for most of his adult life, 9 years. I wasn't going to speak of Mark's addiction, and I know he wouldn't have wanted to be remembered by this either. Mark lived with a lot of shame and guilt with this disease. This part of his life taught me how powerless I was as a mother and the hold addiction had on my son. Mark hated using and suffered physically, emotionally, and financially. As parents, we truly did everything in our power to help our son and to save our son and to love our son. Mark tried really hard to stay on track and make a plan and stick to it. Mark was a humble human being. It would crush him if he hurt someone's feelings or caused a problem because of his actions. Excuse me. Mark would do whatever he could to redeem himself. Mark wanted so much to make us proud. He made mistakes, but he was always remorseful. I need to be clear and say without a doubt that my son was the strongest, bravest soul I ever knew. And I'm proud of him. I'm proud of you, Mark, and what you did and conquered in your short life. It was a privilege to watch you grow up, and I will cherish the memories for the rest of my life. Having said that, I would like to explain to the court who Mark was, since it was brought up that no one knows who Mark was. The defense attorney not only disrespected my family and my son, but it was cruel by suggesting this and insulting. I knew who Mark was. He was not a drug addict. He was not a troubled young man. He was not an alcoholic. He was not a habitual felon. He was not a violent person. He was not a thief. He was my son, Mark Thomas Garrity Jr. He was a human being that was wrongfully accused at the age of 27 years old, murdered in broad daylight. The only harm that my son would cause was to himself. He was not aggressive or confrontational. The defendant has no respect for human life, and he thought nothing of my son's life, never offered an apology, showed zero remorse while my son was lying in the street, suffering and bleeding to death. He could care less, clearly, as he mopped his floor. The last time I saw Mark was on April 4th, that Tuesday before he was killed. I brought him his Easter basket. Mark had a sweet tooth and loved chocolate, but he wasn't coming home for Easter Sunday, so I wanted to see him, and he came with me to take my grandson, his nephew, to see the Easter Bunny. This is the last photo that I took of Mark when we took my firstborn grandson.
What's your grandson's name?
Grayson Garrity. And he loved being an uncle. This is the last photo taken of my sweet son holding his nephew. The last thing Mark said to me was, "Thank you, Mom. I love you." Mark died on Holy Thursday, April 6, 2023, and now our holidays will have an emptiness forever. April 6, 2023 marked the beginning of a new life filled with sadness and pain. A piece of my heart was destroyed. An ache no mother ever gets over. I know I will never be able to accept this senseless attack. My son was robbed of his precious life. Mark had so much to live for. He loved life. And he had so much potential. He was so kind and loving and funny, handsome, very handsome, and loyal. He was the best of me. Mark was a great big brother. He was the oldest of my 3 sons. Mark loved his brothers, Luke and Jake, and they were all very close with 2 years between them. Mark's brother Jake has autism, and Mark would always reassure us how he would take care of Jake if something ever happened to me or his father. Mark's brothers lost their best friend, their protector. On April 6, 2023, I was driving home from work, and I had pulled over because I had terrible pains in my chest, taking my breath away. I thought I had just drank too much coffee that day, and then in the middle of the night, we got the phone call that Mark had passed away. I tell you this.
Survivors can do what no one else can do inside of a courthouse, and the way that they do it, they bring the victim to.
I know this was my instinct as a mother, and I was wondering why I hadn't heard from Mark that day. He called me every day. If only I could have gotten to him and held him. Mark died alone in the hospital at 5:11 p.m. Our worst nightmare, when the events of that day were told to us, we were left with more questions than answers. Why would someone stab our son? Why was the killer not arrested for 14 days, burying our son and telling our friends and family that the monster that killed Mark was still working in the same store, business as usual? You did not take the law into your own hands. The defendant lied and blamed my son, an innocent victim. Mark was trying to get away. He saw what he was. He saw he was a monster. He was in a dangerous store. I saw all the call logs from 911. How could someone kill someone in the city of Raleigh, North Carolina, and not even be arrested that day, or the store closed down as a crime scene? From the beginning, we have fought for our son, defending our son. WakeMed trauma surgeon was incredible and very compassionate. And he seemed to be the only one on that day that showed us sympathy and tremendous compassion. The trauma surgeon actually cried when he was explaining Mark's injuries. The doctor told us this was no stabbing. This was a brutal slaying of our poor son's body. For 19 months, we have been fighting for our son, at times not knowing how to get through because the grief has been so much. Mark was sadly in a dangerous store that day and came face to face with an evil monster. Please understand, my son will always be loved and missed beyond words. Mark did not deserve his life to end that fateful day in order to heal and maybe one day have this agonizing pain and heartache soften some. This monster needs to go away for the rest of his life for the murder of my sweet firstborn son, Mark Garrity Jr. The consequences a coward is handed are nothing to what I have wished for him. I respectfully request the court consider a maximum sentence for taking the life of my son in broad daylight for no reason. I'll have to learn to live with my life sentence, consumed by sadness and longing for one more word, one more hug, and one more day. I'll say it again. Mark was wrongly accused and lost his life for nothing. An innocent victim. Mark was a wonderful son, brother, grandson, and friend. He is an angel, my sweet angel, my sunshine in the darkness. 27 things about Mark. Mark loved Christmas. Mark loved his family. Mark loved the Lord Jesus Christ. Mark was a hard worker, no matter what job he had. He was dependable, respectful, and took pride in his work. Mark loved boxing and MMA, and he trained in both of these sports. Mark loved Star Wars, obsessed over Star Wars. Mark had great hair, thick, sandy blonde, wavy hair from the time he was a little boy. He hated having his hair cut. Mark loved cookies, especially my homemade chocolate chip cookies. My Christmas cookies I would make every year, I would have to hide. I would have to hide them from him so that I had them to give out to people. Mark loved his Nana. He never really got over when my mother passed away 5 years ago. Mark loved our pug named Tinkerbell. But he also loved all of our pets. And a lot of our pets we acquired because Mark brought them home because he had found them.
Amy Garrity there in her own words speaking about her son, 27 years old, killed by...
Mark always wore t-shirts and sweatpants, but no matter what, he had the best sneakers on. He loved his Air Force Ones. Mark was extremely funny and quick-wit. Mark has a great smile and a dimple on his cheek. Mark was very sensitive and hated to see people upset or struggling. Mark always asked me to send someone money, random people, if he himself was not able to help them. Mark was a listener. Mark loved music, many genres, old school hip hop, Motown, disco. Mark loved milkshakes, especially from Cookout. Mark grew up in Wake Forest, but lived in Asheville and Wilmington, North Carolina as well. Mark loved his brothers, Luke and Jake. Mark hated the cold. Mark was afraid of heights. Mark wore glasses since he was 4 years old. Mark loved children, and he was a kid at heart. Mark loved bacon, egg, and cheese biscuits at any time, day or night. Mark could play the guitar. He took lessons for years. And number 27, Mark isn't in pain anymore, and he is perfect. And he is my son. I love you forever. I like you for always. As long as I'm living, my baby will be. Mark will never be forgotten. Mark left his mark on this world at only 27 years old. Thank you, ADA Patrick Latour. Thank you, Emily Boone. And thank you, Your Honor.
Welcome back. We've been watching the sentencing hearing.
Need to unmute myself. Wow, that was a hard one to go through. And now to finish off, we'll hear sentencing. It's also a brief, about 20 minutes, that we're gonna hear the sentencing of Zarka, because now we're gonna find out exactly how much is gonna get.
That portion, but it also said, but the decision to depart from the presumptive range is in the discretion of the court. And I respect our law and laws, and I respect our legislators. They're not sitting here. They're not sitting here. We have 3 branches of government, and the judicial is one of those branches. I respect the legislators, and they give me the opportunity to look at the law and follow the law. But they also tell me that I have discretion. In any republic, at least in these United States, when the judge, he or she, has discretion, that means judicial discretion. And with judicial discretion, for any judge, he or she has to look at the totality of the circumstances. I keep asking myself in this case, with all of the things that the supporters of Mr. Zarka said, and even Mr. Zarka's own words, with all of the things they've said about him giving the shirt off his back, giving people drinks and food, if that's who he is, why wasn't he that person on April the 6th of 2023? Why not just give Mark the drink? If that's who he is, why not just give him the drink? And it doesn't escape the court. If you look at that video, when Mr. Zarka comes around the counter and pulls his knife out and heads towards Mark. Where was Mark? Mark was headed towards the counter. What did he have in his hands? A bag and ice cream. Well, if Mark was this true person that was going to just rob and steal, he had the ice cream in his hand. In plain view. It tells me, using reason and common sense, he was probably walking to the counter to pay for the ice cream because it was in his hands. Was he going to conceal that right there at the counter? He had the ice cream in his hands. Mr. Zarka even testified he never actually saw Mark conceal the Gatorade. Let's say Mark did conceal it. That's fine. But if this man is somebody who says he will take the shirt off his back and give it to somebody, give them drinks and food, why not do it that day on April the 6th? As I said, Mark was walking up with a bag and ice cream in his hand. It would have been a different story if Mark had walked in with a gun and said, with a mask on, give me all your Gatorade. He didn't do that. He didn't walk in there with a gun and say, give me all your Gatorade. He didn't try to hide his face. From what I saw, I think he was walking up to pay for the ice cream. And it wouldn't shock me if the ice cream was cheaper than the Gatorade. And he may have had enough money to pay for the ice cream and not for the Gatorade. But did he deserve to die for that? No. 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 You know, I'm a judge.
The judge, this whole trial, this judge has been great. Judge Gregory. He is not just going to lay out a sentence, he is going to tell a story and then deliver.
I want to make sure I'm clear about this. His addiction did not kill him. Mr. Zarka did. An addiction doesn't care about your race, your gender, your religion, your sexual orientation, because it's a disease. That's what it is. It's a disease. And I commend Mark for recognizing that and wanting to deal with it. I commend him for that. And I want to remind you, Shauna, where are you? You have a responsibility to continue to remain sober. Do it for you. You have that responsibility. You're not a bad person. You're not a villain. You have a disease. That's what it is. Mark had a disease. That's what it was. It hits everybody. Doesn't make a difference the type of job you have either. It's a disease. I think Mr. Latour said, he said, Judge, the state did its job, the defense did its job, and the jury did its job. And he politely said, or inferred, that now it's time for the court to do its job. And Mr. Latour and Mr. Newsom, I say ad nauseum, without fault, that I've been a prosecutor, I've been a defense attorney. The DA has an objective, the defense has an objective, but the court has a responsibility. And I took an oath. I took an oath to follow the law and to be fair and impartial. And I live by that. And there may be some in the audience, respectfully, or out there, that want to blame people. This court takes I don't have a dog in this fight. But what I do have, and what the citizens of North Carolina have entrusted me to do, is to be fair and impartial, follow the law, but not forget my common sense. My common sense tells me, respectfully, that Mr. Zarka had a choice. In that video, he gave a little boy chocolate. He gave a little boy chocolate. That was somebody's son. He could have given the Garrity's son the Gatorade. He could have done that. He could have done that. He didn't have to pull out a knife. He didn't have to go towards your son and then stab him in the heart. In the heart. And if he was so scared and afraid for his life, he could have stayed behind that counter and called these people that we call law enforcement officers. When your son came to the counter, he could have said, I know you've got Gatorade and I know you've stolen it. I'm not going to let you come back to my store anymore. You're trespassed from my store. He could have said that. Reason and common sense. Reason and common sense. $3.25, $3.90, whatever it costs for a bottle of Gatorade. That's worth losing somebody's life over? Really? Are you telling me that's worth it? And I'm going to say this, for those of you that may be animated in the audience, for those of you that said, Mr. Zarka is this and that, if this had happened to your child, you'd be sitting right behind Mr. Latour, sitting right behind him. Because if you're a parent, you love your child. So no, Mark Garrity is not, in my eyes, a thief, a crook, someone addicted to drugs. He's a human being. He was a human being deserving of just that modicum of respect as a human being. So, yes, I will find Mr. DA and Mr. Newton. I think the court can recognize the mitigating factors that have been indicated or enumerated by Mr. Newton on the record. But the court will also find these mitigating factors in my discretion do not outweigh a presumptive sentence. Given that factual pattern that occurred and what this court saw, no, this is not a mitigated sentence. And my job is not to punish, because I'm not up here to punish out of any selfish means and so forth. My job is to be fair and impartial, and also not to forget to use my reason and common sense. My reason and common sense tells me respectfully that this sentence is deserving of a prior record level 1, Class D felony. I will sentence Mr. Zarka to 64 months minimum to 89 months maximum. That is the maximum I'm allowed to do under the law, and I'm going to do that. I'm going to give him all the credit he's entitled to by law. This is an active prison sentence. I'll make a finding of fact that he's serving a lengthy sentence, and when I say lengthy, it will never compare to the sentence that Amy and Mark Garrity Sr. will have for the rest of their lives. I had the opportunity, as I always do every morning, to text my son and tell him I love him. And he always has the opportunity to respond. Amy and Mark won't have that. So, give him all the credit he's entitled to, and make us finding that he's serving an active sentence. Therefore, I'll waive the court costs unless there's an agency that needs to be heard. When he comes out on post-release supervision, he shall have no contact whatsoever with the Garrity family. While he's incarcerated, he shall have no contact with the Garrity family. While he's incarcerated, he shall participate in any anger management classes that are available to him while he's incarcerated. If in fact there are no anger management classes out on post-release supervision, he shall be required and ordered to participate in any anger management programs that are available after consulting with his post-release supervision probation officer. While he is on post-release supervision, it may sound nominal, but I still believe it's important to have him do some community service. I'm going to order him to do 100 hours of community service while he is on post-release supervision, which means that when he comes out of prison.
All right, the judge sentencing.
All right, so that was the sentencing. I loved the points that the judge made. I loved how he presented the case, how he spoke to the family about the case and everything. It was just, he did a really, really great job. I loved the job that this judge did in terms of sentencing. I know that for a fact the judge was in his mind, he was killing himself that he only could give 5 to 7 years to him, because I'm sure if the judge could give more, he wouldn't have given more, but he had to follow the guidelines on the charge that the jury did find him guilty on. So, and those were the guidelines, and he did sentence him to the maximum possible. So you could see in the face that the judge wanted to throw the book at him and lock him in and throw the keys away, because that's what he deserved. He should have gotten more than 5 to 7 years for what happened to Mark, because it is not a good sentence. I mean, after what we watched happening in Colorado last week, I think this one at least is a little bit better. He's gonna be there for a long time, and like we were discussing in terms of his health, we don't know if it is actually gonna make it, because he sadly said that he had cancer. So we'll see, and we don't know how the prison system healthcare is. So well, we'll see. But yeah, so that was the convenience store unaliving trial. Again, it was another one that went down the radar. Not a lot of people, probably because there was not really a feed or anything for it, but that's what we do in this channel. We try to find cases that are not really out there. We try to pile the information, talk about it, and treat like a normal trial and see what happens and everything. So it's what basically we do on Saturdays over here on True Crime Addict Corner. So next week the plan is, there is another case that I actually just found while we were watching this one that popped up on my for watch page YouTube thing. So there's another one, but I need to investigate if there is actually a lot of more information, because this one is not even on the Court TV website. So definitely gonna have to do a lot of research on this one. So but that's probably gonna be our weekend trial, because hopefully Monday we have normal trials start back up, either normal trials, or what we do is what I want to do as well is either do some parole hearings, because I think they should start as well back in on Monday. We'll see, because there is the trial of Billy Wagner, the Pike County massacre, the last defendant to go to trial. That one would be a good trial to follow, but I'm concerned of two things. First, the length of it, because we do have the Jason Chan trial starting not next week, the week after, but also the audio. But I guess we can see and try to sorry, excuse me, I think Nightbot 95, it's dying behind me. No, it's all right. But so we can see. I mean, we can roll with the punches. We can always pause Billy Wagner case if we have to before Jason Chan starts. Otherwise, we'll figure it out. I mean, there is plenty of time, and we'll see what happens. But it's been a really good day with you all. I really appreciate everyone that spends time here with us. With it's a great little place to be on a Saturday afternoon, especially when it's freezing out there. But yeah, I just wanted to thank everyone to that spent time with me in here, that pressed the like, shared the stream. It was supposed to, but I don't know. The normal night bot was not working, but oh, it is working. But yeah, thank you very much again for everything. Have a great afternoon, evening, morning, wherever you are. And yeah, 10-4. Peace out.